All right, let me get these over here. I forgot I had my dots on. Take those off. Okay, I found the most interesting case. I'm kind of waiting a little bit to see if our good friend Sprinkle Donut can come on. She's not feeling well today, and I told her it's fine either way. I totally understand. Headaches are the worst in the world. So let's kind of talk about what we're going to talk about for a minute. Let me split this screen so we can see it. Very interesting situation. I had no idea until I was like, you got to be kidding me. Okay. Um, let me pull this up. All right. Now, this particular case is kind of interesting because this man has been on death row for 25 years. He's had multiple appeals. Even the state has decided they made a mistake. Yet he still sits on death row in Oklahoma. This is wild. I've never seen another case like this. And let me get this pulled up so we can talk about it. Okay, over here. Hmm. Okay, let me find my prior Glossip. Yeah, you can, when you pull things up on Chat GPT, you can save it, but you can't go from like your iPhone to your account on um, over on. Come on, stop that on your computer, etc. It's like you either have to do it from your iPhone or you have to do it um, from your wherever you started at. Is where you do it. So here we go. Let me pull this back up. Come on, damn it! I just had this. I mean, like just 10 minutes ago, I had all this pulled back up. Here we go for Glossip. Now let me go back over here to the beginning of this case. Okay. Do. Boy, I didn't know I messed with it that much today. My Glossip file. Okay, strange last name, right? One of the things that happened in this case in Oklahoma was there was one person that was an eyewitness, but then later this eyewitness recanted his statement. So that left nobody as a witness to the case, right? Okay, so then this goes back years and years, okay? There's also the oral arguments. We're going to show that too. So here we go. So this is about Richard Glossip, and he was convicted of murder for hire in 1997. That's how old this is. The actual killer, Justin Sneed, admitted to the killing. So he was convicted, but somebody else admitted to the killing. All right. Sneed avoided the death penalty by testifying against Glossip. This case exploded. The entire conviction rests on testimony of the killer himself. So you have the guy who actually did the murder testifying against an innocent person. So here's the hidden evidence and the allegations that go with it. The prosecutors allegedly failed to disclose mental health issues of Sneed, statements affecting credibility, and then that triggers the Brady violation. So there's that. That's a huge issue. So then the next thing that happened is the Oklahoma Attorney General supported a new trial, said the conviction was unreliable. And that's extremely rare for the Attorney General to make that discussion or make that decision and discuss it. Then this case goes over to the Supreme Court. Okay, Supreme Court of the United States had decided. Oh, here's our friend. Here we go. There's Sprinkle. How you feeling, girl?
Hey, oh, I got a horrible
Uh,
migraine.
I hate that
Horrible
for you.
migraine. Oh,
I'm so sorry. Well, if you,
yeah, it just
you know,
comes on for no reason and then it just does not go away.
well,
It's just,
if you feel like you can't stay, just say I can't stay, and that's fine. It's
okay,
okay.
yeah, yeah. I want to be here to support you.
I know. Thank you so much. Isn't this the wildest case? Isn't
It
it weird?
is.
I mean,
It is. It's crazy.
how is he still on death row when somebody else already admitted to it and went and was sent to prison for it, but this guy's still on death row? It's
I
so
know it makes me feel like there's a lot of cover up and somebody doesn't want to get exposed.
right. So,
down to the court system, not just the police system, the court system, the judges. It just makes
yeah.
me feel like there's corruption very deep,
Well,
very deep.
we know corruption happens from the case we just did the other day.
Right.
Yeah, the Fitzsimmons case, absolutely,
Yeah. Yeah.
absolutely. That was horrific.
It
She could have went
runs
to
from,
prison.
yeah. Yeah, oh, yeah, she could have lost her baby, you
Hmm.
know. It's who knows? I mean, it could be city officials because he'll file a wrongful claim against the city. It's going to cost them millions of dollars if they let him out.
That's
There's a
right.
lot of repercussions to that. So who knows how deep and wide those veins go?
I mean, I know in Texas the only way you can file is if you are actually, oh shit, I've lost my train of thought.
Wrongfully convicted. That's what I'm
And
thinking.
well, whenever you go before the court and they say, okay, we were wrong, you have to be, the
Right.
court has to say we were wrong in public. I mean, it's called, anyway. Once that
Right.
happens, then you can file. But if they never do that, then you cannot file for the
Right.
money, which is
Well,
not
that's
fair.
that's what I'm saying. I feel like
Yeah.
that's why they're not letting him out because if they do, then all of this other stuff is going to start.
Yeah. You know, I just, the Supreme Court of the United States had to make the final decision on this case, right? Can a conviction stand when the state failed to correct the false testimony? That's part of the questions here. So let me talk about the key legal concepts and this is something. There's the Brady violation, which was them hiding evidence helpful to defense, the Napue violation, allowing false testimony to stand, and then there's due process, which is the fairness of a trial. Now, this is all very important and it all matters. This case is bigger than one man. Can someone be executed based on one incentivized witness? What happens when the state itself doubts the conviction? Those are the two questions in this case. So, it's a man who spent 25 years on death row, convicted with no physical evidence, and now even the state says something went wrong. They admit something went wrong. So, this one witness, who also was convicted of the actual crime, and so the only way that could have happened is if evidence was withheld. We know this, right? So the state itself is questioning. So here we go. Um, let me pull this up. So the exact timeline dates. Let me get this for you on this case. Okay. So in 1997, which is January of 1997, motel owner Barry Von Tress was murdered in Oklahoma. The killer, Justin Sneed, who admitted to it much later, claimed that Richard Glossip had hired him. Then in 1998, Glossip convicted and sentenced to death. The convictions later overturned due to ineffective counsel. Then in 2004, now this is a critical point right here. In 2004, Glossip uh, was retried. Again, he's convicted and given the death sentence based on almost entirely on Sneed's testimony. Okay. Then 2007 comes around. Are you there? Okay. Yeah, I can hear you. Hmm. Okay.
Okay, I'm trying to reset my headsets, my
Oh,
earbuds. I may
okay.
have to go out and come back in. I hit them and it turned the
Fine.
mics off.
Yeah, we know. We always have problems, don't we? We just laugh about it. All right. That's fine. In
I
2007,
think I might have got them.
oh, I can hear you just fine. Great. Great. Okay. Then
Okay,
in two,
perfect. Perfect. Sorry.
okay, 2007, he gets a direct appeal denied by the Oklahoma Court of Criminal Appeals, and that affirms the conviction and the sentence. The next thing that happens to this man in 2015, I mean, this goes on and on, which is kind of crazy,
Yeah.
I know. In 2015, he's near execution. Glossop comes within hours of being executed. Execution is halted due to drug issues because they could not get the lethal injection. They could not get the drugs. Imagine that. And he's innocent. Here's the thing, he's innocent.
Yeah.
2015, a separate case, Glossop versus Gross. The Supreme Court upholds execution method, not the innocence case. So they went back to fight for, well, do we have to use lethal injection or could we do something else? And they said, no, you have to do lethal. 2022 rocks around. There's new evidence. Uh, Investigations reveals possible false testimony by Sneed, suppressed evidence about the key witness, because the key witness had already said that he did it and he's already been convicted. 2023 comes around. Oklahoma court rejects the new claims and says the issues are not enough to overturn this conviction. Then again, Oklahoma, then in 2023, 2024, there's a shocking turn of events. This man is so lucky. Oklahoma Attorney General supports a new trial, which is extremely rare, and the state sides with the defendant. The state says, yes, we're going to retry him. He deserves a retrial. But October 9th of 2024, the Supreme Court argument happens, the oral argument for the United States. Now, we're going to watch this oral argument. I just need to pull it up. So I'm going to get it started. Hang on just a second. I got to go over here to YouTube and pull that up. It's just fascinating, all the things that have happened in this case. All right.
It just doesn't seem like due process was followed, you know?
You're right. I don't think it was.
And it makes always things like this always make me wonder if it was the judge's family on trial, if it was the attorney's families on trial, if it was the district attorney's families on trial and they were this man, how would things be different? How would this end up differently?
Right? Go get the oral argument. This is the oral argument. Hang on just a second, guys. Now, okay, so this is going to be from Prime Crime USA. We have to give them credit for it because the actual, there's an oral argument that's transcribed as well and it's been read aloud, but this is the actual oral argument. So let me share my screen so we can show this and give credit where credit's due. So share my screen.
Why doesn't the president step in on things like this? You know,
that's a good question. I have no idea. So Prime Crime USA, let me make this big.
The governor, the whatever, the governor of the state, somebody should be stepping in. Why is this not all over why is this not a huge news story? Why hasn't it been a huge news story? You know what I mean? Why is it just laying low? It just, it has to be it's a who you know situation, not a what you know situation. Because what we know is that this man is innocent, but it's the who you know that's going to help this situation. And that's really sad because we're all supposed to follow the law of the land and innocent until proven guilty, yada, yada, yada. However, you're guilty when you're proven innocent. Like, how backwards is that?
Because how can he still be on death row over here? It's crazy. You've got the Supreme Court and the state of Oklahoma saying this is wrong, but he's still there. Yeah. Okay. I'm going to play these oral arguments.
And by the time he gets out, his life has been lived in prison.
25 years.
Yeah. Yes, that's a long time.
I'm going to get this playing, and then I got to go grab the charger for my phone. So y'all just hang on just a second. Here we go. Now, all right. All right, get past their commercial here.
We will hear argument this morning in case 227466.
All right. Let me put my dots on just so we don't get in trouble.
Mr. Waxman.
Mr. Chief Justice, and may it please the court. Richard Glossip was convicted on the word of one man, Justin Sneed, the undisputed murderer in this case. Oklahoma has now disclosed evidence revealing that Mr. Sneed lied to the jury about his history of psychiatric treatment, including the fact that a prison psychiatrist prescribed lithium to treat his previously undiagnosed bipolar disorder. The prosecution suppressed that evidence and then failed to correct Mr. Sneed's perjured denial, just as it suppressed evidence that in the middle of trial, in violation of the court's sequestration order, Sneed altered his testimony about the knife wounds on the victim at the urgent request of the prosecutor, who then falsely denied to the court her prior knowledge. There is no adequate or independent jurisdictional bar to review and no warrant for an evidentiary hearing. As to independence, the court's opinion is suffused with merits determination on the Brady and Napue claims, and certainly there is no, quote, clear and express statement that the court's decision is based on a bona fide, separate, adequate, and independent grounds as long required by this court to preclude review, nor is there any adequate bar. By rejecting the state's waiver, the court created a jurisdictional threshold it had never applied in any other case. The disposition was, quote, without support in prior state law, as required by over 60 years of this court's precedent to establish adequacy. No evidentiary hearing could alter the conclusion that Mr. Glossip was denied due process. There's no dispute that, contrary to Sneed's sworn testimony, the state's own suppressed record shows that he was in fact treated by a psychiatrist for bipolar disorder.
Okay. You know, we have to stop every once in a while for fair use and discuss it, and that's fine. So far we can see what's kind of going on here, that he lied to the courts. The courts had the information, but nobody said anything. It's absolutely a Brady violation. So my question on that is, if they know they have this Brady violation, what they do about it? What they do about it?
Right.
So I have to sign back into my phone now. Now, I'm going to ask, what did they do about the Brady violation? Hang on a second, then we'll go back and listen some more. Because that's amazing. That's really bad. That is really bad. Okay. All right, let's pull this up over here. Okay, I'm going to put it over here, over into this one. Hang on a minute. Also, case Brady. My goodness. Okay. So in this case, the Brady violation was actually the key witness, Justin Sneed, who is the admitted killer and the only person that tied Richard Glossip. And the Brady violation was his diagnosis and medication history. So the court that could affect his memory, his truthfulness, and his credibility. So that is what the Brady violation is in this one, and the jury should have heard and fully understood. The jury should have heard all of these things. So many things were left out that has caused this. Now we'll go back and listen to the oral arguments. Here we go.
Order, just as there is no dispute that Sneed changed his testimony about the knife at the urgent mid-trial request of the prosecutor, who then falsely denied that very fact to the court. This court should reverse and remand for a new trial. I welcome the court's questions.
Mr. Waxman, you place quite a bit of weight on the notes from Smotherman and Ackley. And from your opening statement, you clearly do not agree with them. Did you at any point get a statement from either one of the prosecutors?
Yes.
Did you interview them?
Well, to be clear, we did get a sworn statement, which I believe is at page 960 of the joint appendix, from Gary Ackley, in which, for among other things, he never mentions the fact that he never mentions the account that he is now provided to in the amicus brief for the Van Treese family. And as to Ms. Smotherman was interviewed both by the legislature's independent counsel and by the Attorney General's independent counsel, Mr. Duncan. She gave different answers each time, none of which was the account she's now provided in an unsworn letter attached to the Van Treese brief.
Well, it would seem that because not only, their reputations are being impugned, but they are central to this case. It would seem that an interview of these two prosecutors would be central They suggest that their interviews were generally about prosecuting capital cases and not specifically about the details of this.
Look, their current unsworn statement appended at the very last minute for the very first time in a merits amicus brief before this court deserves all the benefit of the doubt that they, to which they're entitled. When in the context of Mr. Ackley did file an affidavit, it is in the record in this case, and it is not in any way consistent with his current account.
Did they make themselves unavailable? Sorry to interrupt.
Well, he made himself available. He provided us a declaration.
No, it's what you're saying would make sense if for some reason they had made themselves unavailable. They suggest that they were not sought out and given an opportunity to give detailed accounts of what those notes meant and what they did during the trial.
Justice Thomas, with respect, there is a reason why both independent counsels and the Attorney General of the state credited the account of what those notes show, and their own words, her own words on the notes can't be disputed. And the reason that they gave for that explanation amounts to the fact that in context, this is a prosecutor who, one, destroyed and dispersed material evidence both before and during the appeal of this case and during post-conviction proceedings. Two, she falsely told the court that it had complied with its obligation to provide the substance of all statements by Justin Sneed. Number three, they belittled the formal discovery request for mental health records as a, quote, fishing expedition and said that no such records existed. This is a prosecutor who engineered a mid-trial change in Justin Sneed's testimony and then denied doing so in the court and stood silent in the face of the false testimony that she elicited about psychiatric treatment. And
Mr. Waxman,
Okay, hang on. We're going to stop and talk for a minute. Now, that kind of reminds me a little bit of the Austin yogurt shop murders, because those kids it took 27 years for them to get justice, for it to be reversed, and for them to be released, and for them to actually be able to be paid by the state of Texas. And there was a lot of controversy about that case as far as what wrongs the prosecutors did as well, because it's kind of the same thing when the Brady violations, the same kind of a thing, which I think when you do that, I think that your license to practice law should be taken. Absolutely.
Absolutely.
Because you've disrupted justice. You've taken somebody's life in your hand, and they never had a chance. If you sat in prison for 25, 27 years, what are you going to do? Likelihood that they were 19, 20, 25, 26 years old when this happens, right? So 25, 27, they're 60-something years old. They can't.
No Social Security. They have no income.
Right.
They have nothing.
Right.
Nothing.
So you have to. We have to reverse it to where you have to. Oh God, I wish I could remember the word right this minute. My mind is going 90 to nothing while I'm thinking about this case and everything.
I mean, think about how long we all work. How much
Right.
money we put in each paycheck, and then how little we get at the end with Social Security. So if
Right.
you've never put anything in, you're getting nothing. You're getting nothing.
Right. Okay, hang on a second. I'm gonna pull this back up over here. Okay. Now, we know there was, prosecutorial misconduct. That's exactly what it was.
Oh, absolutely.
The hidden evidence or that Brady violation, that false testimony, I want to find out how long did it take before that was discovered, because that's pretty important. When the state and the highest court in the state says we were wrong, the Attorney General, when they say we were wrong, that's pretty important. There were serious problems with this conviction, and even the new trial. He was convicted twice. He got a new trial, but he was still convicted again. How does this happen? Was it the same attorney both times?
Was it this?
I
Was it the
mean,
same judge? Was it the same judge? Do we
so
know?
I'm going to find out if the second trial was held. Okay, second trial by same judge. Let me find out because it seems to me like under a new judge, but you have the same evidence. I guess because you have the same evidence, you're using the same evidence. It was the same prosecutor. So let me see. Second trial by same prosecutor. Let me
Well, of
ask.
course, the prosecutor is going to be the state, so they're going to have the same evidence to use.
Right. Right.
You're just going to have a different person presenting.
Not in this one. In the second trial in the Glossip case, it was the same prosecutor. So she used the
Oh,
exact
really?
same information. Yeah. So she did it not once, but she's done it twice.
Wow.
It was prosecuted. It was misconduct twice. The Brady violation twice. She knew it, right? Um, I mean, this is kind of like one of the most unfair cases I've seen in a long time. But let's go back and finish listening. It's quite amazing.
Counsel appointed by the court argues that a central element of your case is that the jury would have regarded the matter differently if they knew that the lithium had been prescribed by a psychiatrist as opposed to someone else, because the jury knew about the lithium, and what they didn't know is that it was prescribed by a psychiatrist. Do you really think it would make that much of a difference to the jury?
Well, I think that's not the only material difference here. The fact was not only that that he lied and was allowed to lie when he said that he never saw a psychiatrist, which the defense, it is one thing for a witness to stand up in court and testify on the basis of a promise of leniency by the prosecution. It's one thing for a witness to speculate or be inaccurate about what actually happened. If the jury is told, this is a witness who lied about the fact that he had seen psychiatric testimony and was diagnosed with bipolar disorder, and this is a witness who, at the mid-trial inducement of the prosecutor, changed his testimony about whether in fact he had also stabbed the victim, it very well could have made a significant difference in the outcome of the case.
Mr. Waxman, the issue wasn't about him taking lithium. The issue was about why he was taking the lithium.
Yes, of course.
And so the fact that the jury knew he had taken lithium during incarceration doesn't tell them anything about whether he had a bipolar condition, that his use of drugs would have led to impulsive and violent behavior, correct?
That's correct.
And would have explained the murder, correct?
I'm sorry?
And would have explained the murder. Now, can I go back to the two questions here? I have three of my own, okay?
Okay.
There's a lot, and you spent a whole lot of time in your introduction, a lot of spilt ink here on whether the PCPA is an adequate and independent state ground. I'm not even sure why we're doing all that. When you're right, the court below seemed to confuse the merits with the procedural bar. But it's very clear that a procedural bar is always waivable under Oklahoma law. Legions of cases say that, correct?
Correct. And under federal law.
So once you waived, the only issue before the court was the substantive issue of whether there was a violation of federal law, correct?
Correct.
So that's really the only issue before us. The procedural bar, a lot of spilt ink goes on and on about, is this the first time they didn't waive it? Is it not the first time they didn't waive it? The reason that's true is because they accept the waiver when there's a violation of a right, and they don't accept the waiver when there's no violation of a right. Here they found no violation of a right, so they reached the substantive legal issue and said, we're not going to waive. You don't find any case in Oklahoma law, and your adversary, Mr. Waxman, can tell me, where they found a constitutional violation, either under state or federal law, and said, we won't accept a PCPA waiver. Can't find it because it doesn't exist. So now we're on the federal issue, okay? That's all I'm looking at. Was there a NAPOG? Was there a Brady violation? That's your argument, correct?
Correct.
Now, on the Van Treese issue, that's non-record evidence. So it's not before us.
It's not only not before you, it wasn't the basis on, it wasn't before the Oklahoma Court of Criminal Appeals. It was
So
never
whatever
even
that
suggested
was.
that.
Now, we know we had two independent counsels. At least one of them, if not both, talked to Gary Ackley because he
Correct.
submitted an affidavit.
Correct.
And he said in that affidavit that Justice Sneed was on lithium as treatment for bipolar disorder. Would have been an important fact for the defense to know.
Correct.
So he concedes the basis of the NAPOG violation here, didn't he?
Certainly the Brady violation.
Right. Now, if he's changed his testimony now in unsworn materials, that's irrelevant to us here. And it's irrelevant to the finding the Oklahoma court made below, correct?
That's right.
All right. So now let's go to the substance of the issue that the chief raised, which was, could he have found this earlier? And does that make a difference to the NAPOG violation and the Brady violation? I thought the essence of the NAPOG violation is, was there a falsehood? Did the prosecutor know it was a falsehood? Not whether the defendant knew it was a falsehood, but whether the prosecutor has an obligation to correct it. Is that correct?
It is correct that
Let's stop and talk about it for just a minute under fair use. I forgot to read our fair use disclosure, but we'll get to that in a minute. So Oklahoma does have a situation where if you're exonerated, formally exonerated, that you can be paid a lump sum of money because your life was taken basically for spending years in prison. So in Oklahoma, their rules are very different than Texas on exoneration and how much you can get paid. Okay, so in the cap in Oklahoma, the max they can get is $175,000. Period.
Wow.
So it doesn't matter if they spent 20 years, 10 years, 5 years, 1 year. It's $175,000. That's it. That's all their life is worth in Oklahoma. I have a problem with that. The man would have more than likely made a lot more than that in his lifetime had he not been locked up in prison.
That comes to $7,000 a year for
Yeah.
25 years. For 25 years. Take that 7,000 and let's divide that by 12. Divided by 12, $583 a month.
For your life, $583 a month for every month that you sat in that prison, went through hell, you were innocent. Imagine that.
$583 a month.
That's all that a person is worth to the state of Oklahoma.
Divide that by 30, an average of 30 days, $19 a day.
$19 a day. You do realize if they have a job in prison where they make, I don't know, $1.75 an hour or whatever it is, because some of these prisons pay their prisoners at, so much per hour because they have jobs. He would have been making more than that per day in that prison.
Yeah, $19 a day.
Yeah, it's crazy. Now, Texas, on the other hand, we talked about Texas when we talked about the yogurt shop murders and how the three were actually exonerated. One of the people actually passed away before he got his full exoneration. And they were given a lump sum plus an annuity per year for the rest of their life.
As
That's
it
so
should be.
different. That's what it should be,
As
right?
it should be.
Right.
Yeah.
It's just ridiculous. Okay, well, let's keep listening. We haven't even got to the prosecutor talking yet. Hold on.
both the Napue and its subsequent cases and Brady and its progeny both look to the obligation, the constitutional obligation of the prosecutor, and not what the defense could have discovered.
All right,
Thank
now
you,
let's go
counsel.
to,
We'll get back shortly through the Syrian question. Justice Alito?
You have a question. All right, well, Mr. Waxman, Judge Sotomayor has taken us through the whole case, so maybe there's not much left to discuss, but I did have a few questions. The Oklahoma Court of Criminal Appeals said in paragraph 24 of its opinion, quote, even if this claim overcomes procedural bar,
the facts do not rise to the level of a Brady violation. Why isn't that a quintessential clear statement under Long, even if it does not overcome the procedural bar then, and it goes on then to the federal issue?
Well, I think that the sentence you just read me is susceptible to at least two interpretations. One is the one you're applying, and the other is that they have just finished dispensing with a number of other claims in their opinion, all of which they very clearly, unequivocally barred on state procedural default grounds. When they come to the Brady claim, the court says, even if this claim overcomes procedural bar, I will then now spend the next 4 paragraphs, well, 3 of the next 4 paragraphs, discussing the merits of the Brady claim. And at a minimum, Justice Alito, I think we have to acknowledge that paragraphs 24 through 28, and this is repeated again at paragraph 41 and paragraph 12, that any statements by the court with respect to the state procedural bar are, to quote this court's precedents, interwoven with and influenced by its consideration of the federal constitutional claim.
Why is that so? In paragraph 26, the Oklahoma court goes through the 2 requirements under state law, under 1089. The issue is one that could have been presented previously because the factual basis for the claim was ascertainable through the exercise of reasonable diligence. And then it goes on to the innocence requirement. And the facts are not sufficient to establish by clear and convincing evidence that but for the alleged error, no reasonable fact finder would have found the applicant guilty of the underlying offense or would have rendered the penalty of death. What's ambiguous about that?
Justice Alito, there is no denying that the entirety of paragraph 26 is a near verbatim recitation of the 2 prongs of the state procedural bar. There is also no denying that it is preceded by 2 paragraphs discussing the merits of the Brady claim and succeeded by a paragraph which also goes in detail in explaining why the Brady claim
But what
fails.
does that show? Yes, there's no dispute that they held in the alternative that there was no federal constitutional violation. But there is the Oklahoma statute. It has 2 requirements. They go through the 2 requirements and they say that they weren't satisfied, and they say even if it could overcome the procedural bar, it still would not provide a basis for relief. I don't see what's unclear or even ambiguous about that.
Justice Alito, with respect, let me make 2 points. Number 1, I guess maybe 2.5 points. Number 1, that when the court deals with the Napue claim, which it does not address until paragraph 28, it never mentions procedural bar whatsoever. It is fully adjudicated on the merits. Number 2, I think that one has to concede that at a minimum with respect to the Brady claim, it is certainly interwoven with, and it's physically on the page, interwoven with what may or may not have been an adjudication of the state procedural bar. Certainly it was influenced by it. And this court 41 years ago in Long versus Michigan and reiterated 30 years ago, also in another opinion by Justice O'Connor, reiterated that, and I'm quoting, after Long, a state court that wishes to look to federal law for guidance as an alternative holding while still relying on adequate and independent state grounds can avoid the presumption of federal jurisdiction by stating clearly and expressly that its decision is based on bona fide, separate, adequate, and independent grounds.
All right, going on to another point. You rely very heavily on a note that says lithium question mark, Dr. Trumpet question mark, and you read a lot into that. And the Van Treese family's amicus brief provides a pretty compelling counter reading of that. And you want us to say, well, just pretend it doesn't exist and read those notes the way we think they should be read, those cryptic notes the way we think they should be read, because it's not the material that the Van Treese brief relies on is not in the record of the case. We shouldn't even remand for an exploration of this.
Okay. Now, we're going to stop and talk about something for a second, because the Van Treese family, he was found guilty of murdering a guy, or a guy named Barry Van Treese. Now, let me kind of give you a little backstory here. So this Oklahoma jury convicted this petitioner, Richard Glossip, of paying Justin Sneed to murder Barry Van Treese and sentenced him to death. At trial, Sneed admitted he beat Van Treese to death, but testified that Glossip had offered him thousands of dollars to do so. Glossip confessed he helped Sneed conceal his crime after the fact, but he denied any involvement in the murder. Now, nearly 2 decades later, the state disclosed 8 boxes, now this is a lot, of previously withheld documents from Glossip's trial. These documents showed that Sneed suffered from bipolar disorder, which combined with his known drug use could have caused impulsive outbursts of violence. They also established that the state agrees that a jail psychiatrist prescribed Sneed lithium to treat that condition, and that the prosecution allowed Sneed falsely to testify at trial that he had never seen a psychiatrist. Faced with the evidence, Oklahoma's Attorney General confessed the error. Before the Oklahoma Court of Criminal Appeals, the state conceded that the prosecution's failure to correct Sneed's testimony violated the Napue versus Illinois. So that's why they're talking about the Van Treese's brief. Here we go. Kind of interesting.
As to I'll deal with the remand first, and then the weight that ought to be given to the Van Treese brief's 11th and a half hour explanation of these notes. This case comes to you based on a holding of the Oklahoma Court of Appeals that did not have that account in front of it because the Van Treese family did not present it to the court, and was predicated on a series of factual allegations and interpretations that were presented both by the prosecutor, the Attorney General, and by Mr. Glossip, and fully supported in great detail and with reasoning by the 2 independent investigators, the investigations that have been done.
I get your point. Your point is we shouldn't consider it because it's not in the record, right? That's the short answer.
I think that you shouldn't consider it for a whole lot of reasons, one of which is that it is inconsistent, is not only was never mentioned at a time when surely, if it was the case, it would have been, and is inconsistent with what Mr. Ackley says in his declaration. But let me just say this, Justice Alito, even assuming that this account is true, there's no denying the fact, and it's also in the record, that while his first conviction was on appeal, he was visited in prison by Mr. Glossip's defense lawyer and an investigator, and that is clearly reflected in the notes of both Ms. Smotherman and Mr. Ackley. There are a lot of other things that are accounted for in those notes that have nothing to do with that interview.
All right, let me go on to one other question because the time is limited. You read McCarty, a 2005 case where the Oklahoma Court of Criminal Appeals accepted the state's waiver of 1089, and you rely on that. But there is no reasoning in McCarty. The court simply said that in a footnote, the state expressly waived any procedural bar. Do you read this for the proposition that the Oklahoma court must accept all 1089 waivers in future cases?
I do, but even if I were wrong about that and it reflected the fact that it was a discretionary rule. It is clear from this court's cases, Beard versus Kindler and Walker versus Martin, that a discretionary rule is inadequate unless applied consistent with an intelligible principle that is, quote, firmly established and regularly followed. And going all the way back to the 1960s.
So one departure in the application of a discretionary, in a discretionary rule, if the rule is applied in a discretion in a habeas petitioner friendly way in one case, that's the end of the matter?
Well, I think that there is a non-discretionary rule that is the rule of party presentation that Oklahoma has followed for 100 years, and McCarty is entirely consistent with that. But even if it were simply an instance of some discretion, again, this court said in, 60 or 70 years ago, and has reiterated since, that a declination, the invocation of a state procedural rule, quote, without support in prior state law is inadequate. And in Johnson versus Mississippi, this court said, quote, a state procedural rule is not adequate unless strictly or regularly followed.
All right, thank you.
Okay.
Justice Sotomayor?
Counselor, no matter how we get past this, we have to reach whether the court ruled correctly on the constitutional issue, correct?
Well, I think so, based on my position and the state's position, that there is no jurisdiction.
And everything that the Oklahoma courts have done. You said 100 years of their history, party presentation, the fact that they've never had a case with a constitutional violation where they didn't accept the waiver, correct?
That's right. In fact, in this court's, in the Oklahoma Court of Criminal Appeals jurisprudence, there is a case, it's cited by everybody, Valdez versus the state, which says that the power to grant relief post-conviction when an error complained of has resulted in a miscarriage of justice or constitutes a substantive violation of a constitutional or statutory right. So this is not a rule that the court is, quote, powerless to grant a waiver, or that it does not, in fact, routinely defer to party presentation.
So I go back to this is not EPTA, correct? Our review is not EPTA, meaning.
Did you say?
It's not EPTA review.
EDPA?
EPTA.
Oh, yeah, no.
No.
This is a direct review from a state Supreme Court.
If they reach the constitutional question, and we de novo decide whether they got the law right, correct?
That's my understanding.
So whatever they said their reasons or thinking was, we have to look at the record and decide whether the facts and law support your argument that there were Brady and Napue violations, correct?
Yes.
Now, tell me succinctly why, even assuming their finding that they could have determined this issue earlier, Brady and Napue violations.
All right, I'm going to stop and talk about this for a minute, because let's talk about Barry Van Treese for a second. Now, the thing about this is, and you're listening to Sotomayor, and she actually wrote the opinion of the court on this particular case, and this is what I'm kind of reading over here is her opinion on this Glossip versus Oklahoma. And it says, even the Attorney General accordingly asked the courts to grant Glossip a new trial. The OCCA declined to grant relief because it held the state's concession was not based in law or fact. Okay? Now, because the prosecution violated its obligations under Napue, we reversed the judgment below and remanded the case for a new trial. But okay, so then they get the new trial. But let's talk about Barry Van Treese for a minute. And then we're going to go back and listen to the other side of the oral argument. Barry Ventries, he owned a Best Budget Inn in Tulsa, Oklahoma, and Richard Glossip managed the Oklahoma City Hotel and lived there with his girlfriend. In the summer of 1996, Justin Sneed and his stepbrother approached Glossip and asked him about working for a room. Glossip agreed to let them stay in return for help with maintenance and housekeeping. Sneed, however, had a history of violence, angry outbursts, and substance abuse that included Mary Jane, meth, and Mr. Kane, and some of that boiling acid. So there we go. So those are his drugs of choice. But on January the 6th, 1997, Ventries visited the inn to collect cash deposits. Sneed beat him to death with a baseball bat. Okay. And after killing Ventries, Sneed evaded the law enforcement for several days. Police did promptly interview Glossip, who told them that Sneed had knocked on his door that night with a bump on his head, like somebody punched him. Okay. And we're going to go back and start listening again. Hold on. It's kind of interesting.
Would have occurred.
Well,
I say they, meaning the court below.
yeah, so, the part of the adequacy determination, leaving aside this novel and unforeseen refusal to give credit to the state's waiver of procedural bars, is whether there is fair and substantial support for the prongs of the state procedural default. Here, the court's analysis of diligence, which is paragraph 27 of the court's opinion, defies any reasonable application of state law. The supposition is that Mr. Glossip's lawyers should have brought a claim of constitutional error before they knew the salient facts establishing the error. In this context, we have, number one, with respect to—
It doesn't matter what state law says about that. The question is, what does federal law say about it? Correct?
Federal law, maybe I'm missing something here, but federal law doesn't, the federal requirement of adequacy and independence is federal law, and that definition of fair and substantial support
you
comes from—
misunderstood my question.
Okay, I apologize.
I'm past the procedural bar.
Okay.
I was past it long ago because I think we need to get to the federal question.
I hear you.
All right. So is there a Napue or a Brady violation if they could have discovered this earlier?
The answer to that question is yes, because the adequacy prong of this court's—
Forget adequacy.
Okay. The answer is
Forget
yes.
it. Let's assume they had granted your waiver.
Okay.
All right. Let's assume that. So adequacy and independence is not at issue. Under federal, and this had happened, and it was the first case before the court, and they come up and they say there was a Napue violation, there's a Brady violation. And your other side comes up and says, no, there wasn't, because you could have found this earlier.
Okay. The answer to your question is twofold. Number one, as this court has said in several cases, Brady and Napue do not stand for the opposite of the proposition that the prosecution may hide and the defense must try to seek. That's the antithesis of what Brady and Napue and their progeny provide. In addition, it is simply preposterous to argue either with respect to the the document that is on page 1005 of the joint appendix, that is the jail record, that this document could have been discovered in the face of a solicited denial under oath that he'd ever had psychiatric treatment, and the state's mocking of a discovery request, number one, for all the substance of all statements of Justin Sneed to the prosecutor, which is required not only by the Due Process Clause, but also under state statutory law, Title 22, Section 2002, A1C, which requires the prosecution to produce the substance of any oral statements made to the prosecution by a co-defendant, And how on earth could defense counsel have known that in Ms. Smotherman's files, there was a memo that she sent immediately after the medical examiner testified to Mr. Sneed's lawyer saying, we, quote, need to get to Justin today. The knife is our biggest problem. And then received back handwritten notes discovered in box 8 that, I guess it was box 7, that in fact Sneed was going to change his testimony and say that he did stab the victim. And the prosecutor then, in response to a mistrial motion, affirmatively tells the
Counsel,
court,
the
we're
last-
hearing this for the first time.
The one fact you didn't mention is that there was a defense request for medical records
Absolutely.
that were resisted by the government, and they succeeded. They never turned over his medical records.
That's correct.
So they had no way of determining from his medical records the lithium issue.
Correct.
Thank you.
Justice Kagan? Yeah, sorry. Justice Kavanaugh? Justice Jackson?
So from your colloquy with Justice Alito, it seems that there is agreement that the court in this case applied the procedural bar, right? I mean, at least it's in the alternative, but they did actually apply the bar. Is that right?
As arguably as to Brady, not as to Napue.
All right. So even with respect to Brady, I guess, doesn't that seem to be the problem, though, from the standpoint of AISG when the bar has been clearly waived? I think that was Justice Sotomayor's initial point. Can parties in Oklahoma waive non-jurisdictional procedural bars? They can, right.
Of course.
And what happens when those waivers occur? I mean, do the Oklahoma courts routinely proceed to either evaluate the reasons for the waiver or reject it and continue on anyway? I thought they just accepted. If a party says, this is a non-jurisdictional bar, I have a right to raise it, but I'm waiving that right. The Oklahoma court's standard practice, just like most courts, if not all courts, is to accept that and go on, right?
Yes, like the federal courts, the Oklahoma courts honor the principle of party presentation and adversarial presentation in honoring the waiver of those
As a matter of practice, so we don't need a rule necessarily that Oklahoma always accepts these. They just do it. I mean, that's what, we don't have any evidence that they've ever rejected it, correct? The waiver.
Correct.
Okay.
And in fact, the rule that this court applies on the adequacy prong is that it is the refusal to accept a waiver is not adequate unless it has been done consistently in the past.
Correct. Thank you.
Thank you, counsel.
Nothing?
Okay, let's stop and talk about this for just a minute, again, under fair use. Now they're going on about this procedural, but remember, there was 8 boxes of evidence not turned over to the defense. 8 boxes. That is huge. Now, we also just understood that the medical records were never provided to the defense. I mean, they were requested over and over, but they refused to provide them. I don't know if, I don't know if it's HIP. I don't know what it is, but it's kind of strange that they were never provided. But so let's talk about exactly what the jury did not hear that caused this, right? What the jury was told is that the killer says Richard Glossip hired him. He's the main witness. Justin Sneed admitted to killing him, but being a paid killer. The jury sees a cooperating witness. He's given a clear story. There's motive. There's accusations. However, there is a credibility issue here. Sneed had psychiatric concerns, medication histories affecting his reliability. That impacts his memory and his truthfulness. The inconsistencies in his story, like the statements didn't fully line up, there was total shifts in his account back and forth, of course, driven by the prosecutor, who, remember, the prosecutor is asking Sneed the questions that's going to put Glossip in prison or, give him the death penalty, right? Now, what's interesting about this is Sneed did not get the death penalty. He got life in prison without parole. How's that fair? Make that make sense, right? Snead avoided the death penalty because say what the state needs and save your life is what happened here. Had the evidence that could have weakened his uh, case was the notes in the records were not fully disclosed. The information that could have been used to impeach him, that's right. Had they had the complete records, they could have impeached Justin Snead. And that would have changed the outcome for Mr. Glossip. That's what happened there. And that is clearly a Brady versus Maryland. So here, let's keep going.
Thank you.
It's a Brady violation.
Mr. Clement?
Mr. Chief Justice, and may it please the court, Attorney General Drummond did not confess error here lightly. Indeed, he continues to defend multiple capital convictions and opposed Mr. Glossip's penultimate cert petition. But after commissioning an independent review, he reluctantly reached the conclusion that Brady and Napue violations by the state's own prosecutors obligated him to confess error and waive procedural obstacles as his predecessor had done in McCarty. That confession demanded respectful consideration and resolution of the issues on the merits, as in McCarty. Instead, the court invoked procedural bars and essentially treated the confession of error as unfounded. The resulting decision made errors on two important federal constitutional issues, and those errors are not shielded by adequate and independent grounds. When the state's one indispensable witness was had bipolar disorder and not a toothache or a common cold, that fact is highly material and merits a new trial. I welcome the court's questions.
Mr. Clement, back to the prosecutors. If you had, if they were using a note of yours from 20 years ago, wouldn't you expect them to call you and have an in-depth investigation as to what your note meant?
I mean, I would expect that, Justice Thomas.
Well, shouldn't these two prosecutors, it seems as though their reputations are being impugned, and according to them, they did not receive an opportunity to explain in depth.
Justice Thomas, that's hard to square with the record here. There were two independent investigations. As Mr. Waxman has indicated, Mr. Ackley submitted a affidavit under oath. And, you know, and ultimately, I think the Attorney General, having commissioned a second independent review, looked at the results of that, looked at the notes, and he has to make his own judgment, because ultimately the prosecutor has to decide whether a Napue violation has occurred.
Well, when I looked at the note of Ms. Smotherman, I couldn't make heads or tails of it. It had a few names, it had lithium and question mark, and she explains what it was. And according to her explanation, if it's true, it was simply about a conversation that Glossip's lawyer had with, was it Snead? Snead. And if that's the case, I don't see how there's any basis for either of those two violations.
So there's a couple of problems with that explanation, Justice Thomas. First, it's inconsistent with her earlier explanations for the notes. Second, when General Drummond is making this determination, the notes don't stand alone. There's also the medical information sheet that was never.
Hang on a minute, because I want people to understand. When you're in trial, it doesn't matter if you made a scribble, if you drew a picture, whatever it is. Everything from that table is boxed and kept. Everything. They don't throw away any piece of paper. Period. Now, yeah, they're going to throw away a tissue. You know, you wipe your nose, that's what you throw away. But every piece of paper on that table that has anything written on it, they save it. They box it because it's part of the trial. Okay, so just to let you know that.
Disclosed to the
Where
defense.
was that? What was that sheet?
That sheet's at Joint Appendix page 933, and it shows that when he was transferred from the jail facility to the correctional facility, he was under lithium for bipolar disorder. So if we're looking at those notes in conjunction with that medical information sheet, it seems quite the inescapable conclusion that the Attorney General had to make on his own.
I think her point was simply, I mean, even that sheet, is that the sheet that she says the sheriff filled out? That it didn't come from a doctor?
Well, but it's the state's
It was a
only
transport
record
sheet.
that at the point of transfer, he was A, under lithium, and B, it was for bipolar disorder. And so, I mean, again, I think you ultimately have to draw the most plausible inference from all the information available. And
But you didn't, though. Her point is that you didn't ask her, that you didn't have an in-depth conversation with her about it. You're drawing it from the note, and which she thinks is inadequate information.
Well, the Attorney General is basing his judgment in part on the independent investigation of Mr. Duncan. He talked to Ms. Smotherman. Afterwards, Ms. Smotherman says it wasn't a sufficiently lengthy conversation. I mean, at a certain point, but let me put one more contextual point on the table here. The original request below was for an evidentiary hearing, and the state did not oppose an evidentiary hearing. Now, we think if you look at those notes in light of the medical information sheet, there's no need for an evidentiary hearing, but ultimately we didn't resist it below. If the court had granted it, we wouldn't be here. And the Attorney General just wants to get to the bottom of this, but he also, under Napue, has to make his own judgment about whether the prosecutors have elicited perjured testimony and failed to correct it. And his best judgment, based on these records and this information, is that there was a Napue violation here.
But are you saying that that the question of Brady and Napue, or a Napue violation, is resolved because the Attorney General has reached that conclusion?
Absolutely not.
All right, so why wouldn't we send it back?
Hang on.
I mean, it's my understanding send it back for.
All right, go ahead. Go ahead.
What's a Napue violation?
Okay. I want to get the actual for you so we can actually say it the right way. Hang on.
I've heard of Brady violations. I know what that is, but I've never heard of Napue.
Okay.
If I Google it, it'll kick me out, and I don't have my laptop open.
Yeah. Okay. So a Napue violation. This is okay. It was a case that was heard in Illinois, and the simple definition is it happens when the prosecution knows testimony is false or misleading and doesn't correct it. Just like what happened here, because they knew he had a mental health diagnosis, he had bipolar, and he was on lithium. They knew that.
Prescribed by the psychiatrist, right?
That's right. That's right. So that is why it is that particular type of violation. Okay.
Okay, thank you, because I did not
You're
know.
welcome.
I did not know what that was.
Yeah. So I mean, it's kind of like I think the funny thing about this is if you go back and you look at all of these briefs for people that were eventually exonerated, you're going to find the exact same cases are used in every one of them to discuss why it needs to be, what they use to get the reversal or to get the exonerations on these people. It's always those same type of violations.
Yeah, I
Yeah.
can see that. Yeah, definitely.
Okay, we'll keep going.
It just
An
doesn't. It
evidentiary
just
hearing.
doesn't seem like this should be a tough case. I mean, it's all there. Like, what's
Right.
the holdup?
What happened,
What's
right?
the holdup here?
Well, the problem is because there's some evidence. So it's not about guilt or innocence for Mr. Glossip. It's about procedures that went wrong for Mr. Glossip, because not once but twice did they have this trial, and they still failed to provide all the evidence. They did the Brady violation, and it was the same prosecutor both times, and she did not disclose the fact that her witness, the only witness, could have been impeached. Mr. Snead could have been impeached because he claimed that he had not seen a psychiatrist. So
Right.
that's the whole thing. Because eventually we're going to go back and we're going to read some more of this brief. After we have the oral arguments, I'm going to read some of this about Sotomayor's complete opinion on this, because it's very lengthy, but it describes a whole bunch of things that you're not going to hear in the oral arguments. So here we go.
It's my understanding that there's never been a court determination of any of these facts. Justice Thomas is saying there's some disputes about what the notes mean and whatnot. So I guess I don't understand why we wouldn't, at the minimum, have some sort of requirement that a court make a finding about these things.
I mean, look, again, we didn't resist an evidentiary hearing below. We would be satisfied if you vacate the judgment below and order an evidentiary hearing. We do think an evidentiary hearing is not necessary here because I just think if you look at those notes in conjunction with the medical information sheet, there's no factual dispute. I don't think there's any factual dispute that certainly the two in conjunction with each other are Brady material. I don't know how they're not.
Whether the prosecutor actually knew about it, knowledge is imputed to her, right?
I would certainly think so. And so
I think under the law, anything in the prosecutor's possession, which includes prison records,
Amen.
is the knowledge is imputed to the prosecutor, correct?
Right. And ultimately, look, the question is, did she elicit perjured testimony and failed to correct it? And it seems like, especially when you look at it in conjunction with the medical records, and then you keep in mind that the medical records were withheld in contradistinction of, or in contravention of Oklahoma law and Brady, I think there's only one conclusion to be made here. And you can certainly understand why the Attorney General, I mean, if you think an evidentiary hearing is fine, is necessary, then the Attorney General will be there confessing error again, because as you can understand, given all the evidence here of the Napue violation, the Brady violation, I mean, even under Smotherman's explanation that these are notes that she took based on what Snead told her, there's an obligation under Oklahoma law to turn over all the defense, all the witnesses' statements. So and especially in here, there was a request for it.
I'm sorry.
No. So just looking at all of that material, the Attorney General drew, I think, the only conclusion that he could.
Can I ask you, Mr. Clement, about some of the questions that Justice Alito was asking Mr. Waxman about whether there's an independent and adequate state ground here, and really focus on these couple of pages of the Oklahoma court's opinion, which I find difficult, to say the least, and ask you what you make of them.
So a couple of things. One is, I do think the easiest ground to say there is not an adequate independent state ground here is the waiver issue, as opposed to splicing the opinion. If you're going to splice the opinion—
When you say the waiver issue, what do you mean by that?
I mean that it is an established principle of Oklahoma law and federal law up until this point that party presentation, that procedural bars are defenses that the state has to invoke and can waive. And that is 100 years of unbroken practice. McCarty is a perfect example of that. In some respects, I think the fact that there wasn't an elaborate explanation that they were accepting the state's waiver is kind of the point. When the state waives a defense, you move on and you discuss the merits, which is exactly what the court did in the McCarty decision. This court's decision in Trest against Kane, which was a unanimous decision, says that procedural default is a defense that the state must raise or it waives. So you just have this, incredibly unbroken tradition that procedural defects, procedural bars are defenses that the state can waive. And here for the first time, they say, no, that's for us to do, not for you to do, Mr.
And suppose we want to go beyond that, because it is true that we rarely say that there's no adequacy because this is so out of the ordinary. It's a very rare kind of thing for us to say. And if we want to just look at what the Oklahoma court did in terms of justifying its denial of the confession of error and its determination to proceed, how do you describe what they did?
Sure. I think it's easy as to Napue, and it's a little more complicated as to Brady. As to Napue, I think paragraph 28 stands alone. It's their only resolution of the Napue claim. They don't talk about the procedural bars at all.
There might be in that paragraph, the last sentence is an oblique, very oblique reference to the materiality prong of the procedural bar statute.
Well, I read it differently. I read it as a oblique reference to the materiality standard under Napue.
Okay.
But if we're into the world of competing oblique references, that's when I think Justice O'Connor comes to the rescue and says that if you're not clear about it and it's ambiguous, then the federal issue is before this court to decide.
And paragraph 27?
Paragraph 27, I think, is where the court is wrestling with the Brady issue. I think it's pretty clear that's Brady, a Brady paragraph, not a Napue paragraph. And I say
And
that
then you get, like, that's all the way down, right, until the last sentence, which is the moreover sentence. And the moreover sentence might suggest, again, a reference to the procedural bar. Is that true?
Moreover, as to the Brady, it says this issue, and I think that this issue there is Brady, and that's an inference based on the fact that the rest of paragraph 27 is all focused on what the defense counsel knew or should have known, and maybe that's marginally relevant for Brady, but it's completely irrelevant for Napue.
At the most, what you have here in these two paragraphs is very significant discussions of the substance, and then maybe a sentence about, oh, there's this procedural bar thing that we're doing too. Is that correct?
I think that's correct. The other point I would make—
And, you know, in a way, this actually relates to the first point that you made about how unusual it is to deny the state's a request for a waiver here, because that's sort of what they start with. They say they have these two claims, and the state has come forward and said, this warrants post-conviction relief, and we're not accepting that because the state's concession is not based in law or fact. What do you take that to mean?
I just mean, I'm not, I just take that to be the back of the hand to the confession of error. I think if
the state has only come forward with Napue arguments and Brady arguments. Is that right? So they must be saying we're not going with the state because we don't agree with their views of Napue and Brady, as we're going to now explain.
I think that's a fair inference. I also think that one of the things that complicates this is, and maybe I read the one sentence a little differently than Justice Alito did, but they start with the Brady claim, on the merits, if you will, and then, in the context of that, they basically say there was no Brady violation here because you should have known everything you needed to know from the fact that he was taking lithium, and then I think that essentially infects the rest of the analysis about diligence and all of the rest. So I think this is a classic case where they are interwoven. But I will say, and maybe you'd think that that the adequacy prong is so rare that it doesn't apply here. But this does seem to me to be a classic case for it because
of interwoven, therefore not independent.
Well, yeah, interwoven, not independent, but also inadequate because, gee whiz, this court unanimously has said, everybody has always said, look, if it's not jurisdictional, procedural bars are defenses that you can waive. Even this opinion isn't very clear about it. Paragraph 24 refers to 1089D as a procedural bar.
Well, is it possible that they know that they're doing something very unusual here, which is rejecting the state's request for a waiver, and they're just throwing everything in the kitchen sink in. They're saying,
okay, did you hear what she said? They're just throwing everything at it and seeing what sticks. The easiest way to remember what's actually going on here is Brady is hiding the truth. Napue is letting a lie stand. That's the easiest way to think about what's actually going on here in this case, and that's the two problems in this case. So it's very interesting, and I really think that I think the reason why he's still on death row is actually because he is guilty of hiding some evidence of helping the guy hide the body. He helped him hide the body, right? So but I think he does deserve a new trial, and I think he does deserve a new sentence because of the two problems with the Brady and the Napue. So we'll let this go on. Here you go.
And, we don't see the merits of these claims, either the Brady claim or the Napue claim. They're saying there's this procedural bar statute hanging around, and we kind of think that that's been violated too. And we actually don't know, like if you took this piece out, if you took that piece out, how they would have come out.
I think that is fair, and I think that gets you into Michigan v. Long and Coleman against Thompson. I also think it is fair to say what is clear is they have not accepted the state's the waiver of procedural bar defenses for the first time in the court's history.
But Mr. Clement, whether a procedural bar whether the waiver of a procedural bar must be accepted by the Oklahoma court is a question of Oklahoma law, right? The Oklahoma Court of Criminal Appeals can say we always accept these, we never accept them, or sometimes we accept them, right?
It's definitely a question of Oklahoma law. But
and you have exactly one case, McCarty, for the proposition that this waiver must be accepted. Exactly one. Can you cite one other case where we've deemed a state decision inadequate for conflicting with one prior opinion? I thought our decision said that there's inadequacy when they conflict with many quote, past unambiguous holdings.
So, at least according to the dissenters in Cruz, that was a case where you found inadequacy when there wasn't a single case on point, and it was a question of first impression. I would say, though, this, I think it's important to understand McCarty does not stand alone. In addition to accepting the state's waiver in McCarty, the Oklahoma Court of Criminal Appeals on numerous occasions, Valdez, Malacote, both cases we cite in our briefs, they basically treat the bars as things that the court itself can relax or waive. And that is equally inconsistent with treating them as a jurisdictional requirement that can't be waived. That stands, again, against the backdrop of Oklahoma party presentation principles, this court decision in Trest v. Kane. The 10th Circuit has treated 1089D as a procedural bar that the state can waive. And I think ultimately the question for adequacy, this court's case say a rule is adequate, a state rule is adequate if it's firmly established and regularly applied. The question for inadequacy is whether it's an unexplained departure from past practice.
Thank you, counsel. Justice Thomas, anything further?
Just one point with respect to the transport order. I think my concern is that in their letter, the prosecutors say they did not see the transport order until 2022. So my problem is if they never saw it, then how is there a Brady or Napue violation?
So I think there's a Brady violation because whether they saw it or not, it was something that was available to.
No, they say it was not in their files.
I don't think, let's keep in mind the precise dynamic we have here, right? This is, the interview takes place before the second trial.
Hang on. If you have 8 boxes of undisclosed information that was not given to the defense, then how do you know whether you had it or not? Were these boxes just somewhere out in, I don't know, La La Land? I don't know. That makes no sense at all, does it? So there's something definitely wrong with them saying they never knew they had it, him saying they did know they have it, and then there's the 8 boxes of evidence never given to the defense counsel, which is the Brady violation. So here we go. Wow.
So Sneed has been in state custody for close to 5 years at this point. He's been transferred from the jail to the correctional facility. I think the state is charged for Brady purposes with that transfer sheet.
But wouldn't it matter that whether or not they have it? Again, I go back to the prosecutors. What I'm hearing is, and they're hearing, is that they did not turn over Brady material or that they permitted false testimony to take place. And they're saying, look, it did not happen. And why wouldn't they be interviewed? Why don't we have materials from them other than in an amicus brief in this case?
Well, with respect, Justice Thomas, you do have materials from them. Ackley's affidavit is in the joint appendix before this court. And it's not like Smotherman never talked to anybody. She's talked to people at various junctures, and her story has changed over time. Again, I don't want to overstate the point because we didn't resist an evidentiary
But
hearing.
they are central to this. It would seem like any dealings with them would also be central, and we would not be arguing about Napue and Brady if that had been cleared up.
I think they would still be submitting amicus briefs with new stories. And at a certain point, you got to deal with what is in front of you and what is in the record. And the Attorney General had to deal what was in front of him and in the record. And particularly when you read the notes, in light of that sheet, all of which is in the record now, I think General Drummond made the correct
So what are we
conclusion.
to do with the point that they make that they were frozen out of the process?
They had access to both independent investigations. And I think at a certain point, if I were in their positions, I'd be complaining about the process as well. But, the ultimate process that I think matters here is the process in Glossip's trial. And that was fundamentally distorted when he is allowed to make the lithium use innocuous by saying, it was for, common cold and I've never seen a psychiatrist.
Boom.
Justice Alito? Justice Sotomayor?
At least one of the two prosecutors was interviewed in some way, because we have an affidavit from him that was provided before the OCCA
Yes.
while this case was pending, correct?
That is absolutely correct.
Do you know, as a matter of fact or not, whether or not the first prosecutor, I can't say her name,
Smotherman.
whether she was interviewed?
I mean, I know she was interviewed by Duncan, who is the independent prosecutor appointed by the Attorney General. I think she also talked to people in the context of the Reed Smith independent investigation, but Mr. Waxman may be able to fill that in.
So I'm having a hard time understanding what the current claim by both of them is. We weren't able to give our full story. They were interviewed, correct?
My understanding is that they were interviewed. I think they do not think that the interview was as long-standing and as interactive as they had hoped. As I say, I mean,
But it wasn't as if they were boxed out.
I don't believe that they were boxed out. And again, the Attorney General here
Can I go back
had
to your respectful consideration to an Attorney General's confession of error? And Justice Jackson asked you whether the court has to accept a confession of error, and you said no. And I think that's correct. The court, as I understand the rule of confession of error, it's especially relevant to questions of fact, correct? Not questions of law. The court has to be satisfied that there's a basis in law and fact for the confession, correct?
I think as to both, it's respectful consideration, and I think it's at its zenith when it's prosecutorial misconduct, because I think the prosecutors are in a particularly good position to judge starting with what does Dr. Trumpet and the notes mean in the context of a community where everybody knows that Dr. Trumka is the sole psychiatrist at the jail. I mean, I think a prosecutor is going to have a good basis to say, yeah, everybody knows that's just some kind of shorthand for Trumka.
That's an issue of fact. And the AG says, if my prosecutor says she didn't know, I'm not accepting that because she should have known.
And I don't find it plausible in light of everything that I now have before me. And there's the question of what Smotherman had before in 2003, but now there's the question of, because I think the Napue obligation on the government is a continuing one. So when they're looking at it, they're looking at the testimony that their prosecutor elicited. They're looking at that in context of the notes and the medical information sheet. And General Drummond reached the conclusion, regretfully, but reached the conclusion, our prosecutors elicited perjury here and a man's going to go to his death. We can't allow that to happen.
Thank you.
Justice Kagan? Justice Kavanaugh?
And your view is that the result likely would have been different, right?
We think the result would have been different with respect.
Let's stop for a little bit of fair use right quick, because I need to read this for our live stream. This live stream includes excerpts from court proceedings and other publicly available materials for the purpose of commentary, criticism, and education. All content is used under the fair use doctrine pursuant to Section 107 of the Copyright Act of 1976, which allows for use of copyrighted material for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. This broadcast is not intended to replace the original sources. Instead, it adds analysis, context, and discussion to help viewers better understand the legal issues presented. All rights are reserved. All rights to original content remains with the further rest with their owners. So there you go. We've got that out of the way. Now, we're going to go back and start listening to the rest of this. It's kind of interesting, isn't it? I mean, he's admitting that the prosecutors basically committed they exactly hit it. They hit it. They knew it, because what they're talking about, this jail transport sheet, is this sheet that goes with the prisoner when they go to the prison. It comes from the jail. that talks about everything that's wrong with these people. It's their whole history while they were in that jail. Everything's on this sheet. So when you just okay, when you work when you send somebody to the Texas Department of Criminal Justice, and I know this because I've prepared these packets before. This is where this sheet comes from. And before this packet is given to the prison, it goes back upstairs to the prosecutor's office, to the district attorney's office, to verify everything is there and to make sure that it meets the standards. That is what happens. So did they or did they not know? Did they hide it or did they not hide it? Here we go. Let's keep listening.
To the standard that's applied under Brady and under Napue.
And can you spell that out? I mean, I think it's obvious, but spell out why you think that.
Well, this is a case where there's just no disputing the fact that the state has one indispensable witness. That witness is Snead. He's the person who committed the murder. He's the person until the police talked to him. Glossip was only charged as an accessory after the fact. So there's every indication this is the absolute critical witness. And if that witness lies on the stand, perjures himself on the stand, that seems to me that could have a reasonable probability of leading to a different result for at least two reasons. One is, this is the key witness, and the jury has just seen him under oath lie to their faces. And if that comes out, I mean, whatever other problems with his credibility that the prosecutors have at that point, they have a much bigger problem at that point. And without his testimony, there's no way to get the conviction of murder, let alone the death penalty. The second thing, though, of course, is that defense counsel, I think logically, if Snead's testimony hadn't led him away from bipolar disorder, then they bring in a psychiatric expert and they make a big deal about how his confessed methamphetamine use combined with bipolar disorder makes him somebody who could act impulsively and violently, and that opens up a whole nother defense for for Glossip. Now, to be clear, I'm in an unusual position here because General Drummond has not only confessed error, but he's made it clear that he's not going to drop this prosecution or doesn't accept that this is, the poster child for an actual innocence case, and he intends to reinitiate criminal process. But I think he thinks that given the centrality of Snead's testimony and this perjury, this is not a conviction that can stand.
Okay, thank you.
Justice Barrett?
On McCarty, so that is the only case, right?
Well,
you have. I mean, otherwise it's party presentation for a long time, but not zeroing in on the procedural bar issue here. I just want to be sure I understand. I'm not trying to be hostile.
And I'm not trying to be evasive. I don't view it as our only case because I think Valdez and Malicote, both decisions of the OCCA, that treat it as non-jurisdictional because they say the court itself can excuse 1089D if there's manifest injustice or a serious statutory or constitutional error. And that's invoked even in paragraph 40 of the opinion here. So I don't think, the way I think of party presentation and all of that, I don't think that the court can have it both ways. If it's jurisdictional, it's jurisdictional and nobody gets to waive it. And so that's why I don't think McCarty stands alone. And of course, we're talking about the standard is unexpected departure. Okay. Here's the Attorney General's office. We got McCarty, but we got Valdez, we have Malicote, we have the 10th Circuit saying 1089D is a procedural defense that we can waive.
Did you cite McCarty or so in the fourth, let me make sure I've got the sequencing right too. This is the fifth post-conviction application, right? And in the fourth, they also refused to accept the confession of error and the waiver, right?
That is true.
So when the fifth came up, it wasn't as much of a surprise, right? I mean, why wasn't the Attorney General ready at that point to say, but there's McCarty and you can't reject our waiver?
I mean, look, in a perfect world, I mean, maybe we would have done that. But in the real world, we thought we were waiving it. I mean, I know this is like in the weeds, but, we expressly argue that the evidence is sufficient under 1089C, which is the standard for the first habeas petition. So it's clear to everybody. I mean, my friend and your friend, your court-appointed friend says, well, maybe it wasn't clear enough to the Oklahoma Court of Criminal Appeals. But it was crystal clear to them that we were trying to waive it and they weren't going to let us. And I think the fact that, yes, it's 2 cases in the history of man, both involving Mr. Glossip, I think that still puts us well within the adequacy. And the only thing I was going to add, is, I know I've said it before, but I think it's really powerful, is trust against Kane. This court unanimously says, yeah, of course, procedural bars, procedural default, that's a defense. The state can waive it. And the state can waive it not just by intentional relinquishment, but by abandonment. That's Wood against Milliard. And even if there's some question about whether we were sufficient in intentionally relinquishing it, we absolutely abandon it. So I just think this is a case where, and there's a systemic issue here, right? Because, I mean, it's Oklahoma law, they get to do what they want. But if Oklahoma is going to say you can't waive under these circumstances, it's going to create a whole federal courts exam about how it is that a state prosecutor is supposed to confess error when they discover a Brady or a Napue violation after the first state habeas petition has been filed. And, I've tried to think through it all. And I think at the end of the day, there must be a due process right to present that somewhere. But boy,
we don't have that issue.
You don't have it directly. And it's a lot harder issue than whether invoking this as an unwaivable jurisdictional bar for the first time in the history of man is adequate. I think that's a far easier question than the due process question about, is there some ability to bring this kind of confession of error to some court somewhere and get to the merits?
Okay, I want to ask you about the standard of review for looking at Smotherman's notes, because one of the difficulties, I think, with the notes is that, putting aside whether the Van Treese brief is in the record, it's not. It still reveals that there are multiple plausible interpretations of the notes. So are we supposed to?
So let me tell you what the note is in case you did not catch this. The note is they're at the prosecution table and, this trial is going on, right? The trials, people are being questioned and they're presenting their cases, but there is a handwritten scribble and it says on there the name of the doctor, ? And it says lithium. That is where this is coming from. Then they find the record that's going from the sheriff's department to the prison system that says he was seen by the psychiatrist, and the name of the psychiatrist is the name that's on the note, the scribbled notes that were from the trial. That is the notes they're talking about, that they're interpreting. Here we go. Just want to explain that.
To be applying kind of a preponderance standard, that we think it's most likely that they reflect that she knew about the psychiatric examination?
I think that's right. I think it is a preponderance.
Okay.
And I think, not to be repetitive, but I think that's also the standard for the prosecutor. Because the prosecutor in the first instance, I think you want them to confess Napue errors. You want them to confess Brady errors. And I don't think you want them applying a clear and convincing standard or beyond a reasonable doubt. I think you want them to say straight up, if we blew it and there's a Napue violation here, we should confess it.
Justice Jackson?
So just going back to Justice Barrett's question about whether McCarty is your only case, if I'm hearing you correctly, it is not because the principle that you're relying on is the fact that it is firmly established in Oklahoma law and procedure that non-jurisdictional procedural bars are waivable and the courts accept those waivers. They do it when a party waives a non-procedural jurisdictional bar. So it's pretty much every case in which a non-jurisdictional procedural bar has been offered and accepted by the court, right?
That's our view, and I think it's buttressed by the fact that the Valdez and Malico cases, even though they're not sort of confession of error or express waiver cases, they show the Oklahoma Court of Criminal Appeals treating 1089D as non-jurisdictional. Because if it's non-jurisdictional, they can't excuse it because of...
Right, so it fits into the category of a non-procedural, so a non-jurisdictional.
Right.
I think that part of the problem here that is what is confusing about Oklahoma's opinion is that they seem to be conflating what I think are two different bases for not applying the procedural bar, right? One is the waiver and the other is potentially the confession of error. In your discussion with Justice Barrett, you talked a little bit about Glossip 4. And in my reading of that, that was a situation in which there was a waiver expressly made, but I didn't know that there was also a confession of error. Am I right about that?
You're absolutely right about
all right,
that. In fact, it was the least confession of, it was the furthest removed from a confession of error. It's like there's a lot of chum in the water and we just want you to decide the merits, but we think they are absolutely wrong.
And so I think that's really important because the prosecutor, I think, is actually making two different determinations that might be relevant to whether or not the procedural bar applies. The first is whether or not to waive it, which is what they do in Glossip 4. And the second is whether or not to confess error, which they go on to do in Glossip 5. And only the latter, the confession of error, is the one that might call into question the reasons for it. The court saying, well, you're confessing error, but let me figure out whether or not it's based in law and fact, and I'll only accept it under those conditions. If I'm right about that, then the real problem happened with its deviating from the ordinary practice of allowing parties to waive and accepting them. And that's why you said, I think, in response to Justice Kagan, that the waiver track is the easiest way to understand why we don't have an AISG here.
Absolutely, Your Honor. And again, just in all candor to this court, I'm representing Oklahoma. Oklahoma, in a lot of other cases, is going to be saying that's adequate and independent state ground. But I think we want to be in a position where if we make a determination that there's been a constitutional problem with one of our prosecutions, we want to be able to confess that error and get to the merits.
I understand, but I don't want to conflate the two. I mean, when there is a waiver, courts don't ordinarily go into why you are waiving. You say, this is my right to press this procedural bar and I'm waiving it. And the court says, fine, we move on to the merits of the argument. What happened here, I appreciate. The Attorney General goes on to explain the reason why he wants to waive it. It's a confession of error, but I don't think the court gets to reject the waiver if it disagrees with the confession of error, because waiver is a separate basis for, relinquishing the procedural bar.
I agree entirely, and I think ultimately, getting back to Justice Kagan's question, it may also explain why the opinion is sort of intertwined.
Correct.
Because they are sort of treating them as one and the same. And in fact, I think it's, paragraph 25 or 26 specifically says the confession can't overcome 1089D, which is perfect evidence that they've kind of conflated the two.
Correct.
Because the confession isn't what overcomes 1089D. It's the waiver that should, at least historically, everywhere but Oklahoma.
Thank you.
Thank you, counsel. Mr. Michel?
Mr. Chief Justice, and may it please the court. Over the past 20 years, the Oklahoma Court of Criminal Appeals has reviewed and upheld petitioner's conviction 6 separate times, finding compelling evidence that he commissioned the murder of Barry Vantrease. Petitioner now contends that the note, Dr. Trumpet ? Would have so transformed his case as to justify vacating his conviction. That is wrong. The court below correctly rejected petitioner's claims on adequate and independent state grounds, that he failed to show reasonable diligence or clear and convincing evidence of innocence. The Attorney General did not waive those bars in this case, and the court was free to apply them in any event. This court should accordingly dismiss the case for lack of jurisdiction, leaving petitioner free to pursue state law clemency or other available relief. If the court reaches the merits, it should affirm. The cryptic note does not establish any of the threshold elements of petitioner's claim, and perhaps most clearly, the note is immaterial because it adds nothing of substance to what petitioner already knew. Critically, petitioner has known since he received the competency report in 1997 that Justin Sneed took lithium and had a mental illness. But petitioner chose not to question Sneed's mental health at the trial because he knew that doing so would reinforce the prosecution's theory that Sneed was vulnerable to his manipulation. Nothing in the note would have changed that decision or the jury's, particularly considering the extensive other evidence against petitioner, including his motive to commit the crime and his cover-up of the body. The parties rely heavily on the Attorney General's confession of error, but courts, not executives, determine whether to vacate final judgments of conviction. The court here decided the case on the law and the facts. This court cannot ask for any more than that. It should leave the conviction in place. I welcome the court's questions.
What do you make of the absence of statements by the prosecutors in this record and the absence of Ackley's notes from the same meeting?
I think, as the Van Treese family's amicus brief explains, it indicates that the investigation the Attorney General conducted here and the other independent investigations were not particularly thorough. I will note that the Ackley affidavit, this is at JA 940, says that he thinks the mental condition was disclosed to the petitioner with the competency report in 1997, and I agree with that, and that's their witness who I think has conceded an important point against them.
Mr. Michel, I asked, I forget whether it was Mr. Waxman or Mr. Clement, about your argument in the brief that all that's at issue here is whether or not the lithium was prescribed by a psychiatrist or by someone else, and that alone was not sufficient to affect the jury's deliberations. Now, they had responses to that elaborate on what they regarded as the significance of not just who prescribed it, but the lithium itself. In other words, the bipolar determination, and we heard him, emphasize that contrary to what he had said, it's not simply for a cold. I wondered if you could respond to that.
Sure, Mr. Chief Justice. I think materiality, I think this question goes to materiality. It's a comparative doctrine. You have to compare what was in the case before the new information and then determine whether the new information would have made a difference. And I think in this case, that determination can be speculative in some cases. This is perhaps the rare case where the defendant's own conduct sheds considerable light on the importance of the information. After all, as I said at the outset, petitioner has known since 1997 that Snead took lithium. And if you look at page JA 700, that's the Dr. King competency report, it says, does this patient have a mental illness? And the answer is yes, underlined exclamation point.
Okay, let's talk about that for just a second. He's saying that in 1997, this person knew that this guy had a mental illness. Well, knowing that somebody has a mental illness is one thing, but you're on the stand. The prosecutor is asking the questions. You're testifying against Glossip. So Snead is testifying against Glossip. The prosecutor fails to ask about mental health issues. It's a credibility issue here is what's going on. And I think that it didn't matter whether Glossip knew it or not. What mattered is what the jury knew or not, because the credibility is the issue. But we'll keep listening. I think it's interesting.
If petitioner thought that Snead's mental health was important to his defense, surely that would have been a bright red flag that he presented that defense at trial. And the notion that the marginal additional information that he was arguably, based on the notes, treated by a psychiatrist would have changed that decision, I think, is difficult to reconcile with the record. I would also note the way you get from the notes, Dr. Trumpet ? Which I think my friend said they were able to do in a matter of hours because it was well known that Dr. Trumpka was the chief psychiatrist at the jail. They already had the roadmap to do it. Remember, the competency report says that Snead received lithium at the jail. They've had that since 1997. They could have simply gone to the jail and said, who's the chief psychiatrist? And they would have been told Dr. Lawrence Trumpka. And then they could have asked Dr. Trumpka the same question that they asked in 2023. And he would have said, well, if anybody treated Snead, I treated him. But they chose not to do that. And I think, one, that's overwhelming evidence of lack of diligence and that the state procedural bar is satisfied, but it's also overwhelming evidence on materiality, because petitioner didn't do this out of negligence. He did it out of strategy, and that was because, as the Oklahoma Court of Criminal Appeals explained on page JA 991, arguing that Snead had a mental deficiency or a mental illness would have reinforced the prosecution's theory that Snead was vulnerable to petitioner's manipulation.
Isn't there a separate question, though, about just he
boy.
lied on the stand? And in a case where the entire case...
That's right. He did lie on the stand. They lied on the stand. The prosecutor knew, that he was lying right there. But she didn't correct it. Nobody corrected it. Let's stand. A jury, when you've got a jury of your peers over there, and they're listening to all this testimony, in my opinion, if I heard somebody talk about, well, yeah, I got mental illness and I take this and I take that, and for bipolar, whatever. That might make me question whether what they're telling me is completely the truth or not. It really would. I'm just being honest how I feel about that. Because it comes into, is he telling us this because he's getting a better deal? Is he telling us all of this because he's truthful? Or is he telling all of this only because he's not going to get, he's not going to get the death penalty? I mean, the whole thing. And now they're talking about, well, he was vulnerable. He was vulnerable to Glossip. Are you telling me that Glossip is basically sort of like Gypsy Rose Blanchard, and that Goda John and this Mr. Sneed were kind of alike because she was able to talk him into it? Was Glossip able to talk Sneed into the same thing? That's a question, isn't it? Go ahead.
Well, also, if somebody has mental illness, you have to also consider the fact if what they're remembering is actually a recollection of the truth, or
Right.
a recollection of what they perceived as the truth.
Right.
Because
I agree.
mental illness can definitely distort your perception of reality.
That's true. That's true. So it comes back to a credibility issue here, and the jury should have known this, And the fact,
If he's on lithium, if he's doing different rugs, if he's doing different things, that's going to alter reality.
the lithium is not going to work with other drugs properly. So we don't know how the lithium interacted with these other drugs, and we don't know what he was actually remembering. You don't, right?
No, exactly.
But then I'm questioning just at how much of an influence did Glossip have on Sneed? What was the dynamics there? Because that's something we don't really have at this point. I mean, it's just coming out.
Yeah, we'll never know.
Right.
We'll never know.
But isn't it interesting? They went after this 6 times to make a change here, because I think the whole thing is they want to re-sentence him. So at this point, that their suggestion over here is what the state's suggesting is, well, let's just deny this and then let him ask for clemency if that's the best we can do about it. Is that fair?
Yeah,
I don't know.
we don't want to deal with this. We'll just have somebody else deal with it.
Right, because we've dealt with it 6 times already.
Mm-hmm.
That's amazing. 6 times. I've never heard of something like this before. 6 times.
Yeah, that's just insane.
It is insane. All right, let's let him finish this argument. Damn.
Case rested on the testimony of one person and his credibility. If you can show that he lied on the stand when he said, I never saw a psychiatrist and I didn't get a prescription from the psychiatrist. It was, they gave me lithium for a common cold. And then the prosecutor says, well, that was a lie. I better correct that under Napue, and doesn't. That seems pretty material to me. I mean, it's just your one witness has been exposed as a liar.
A couple of responses, Justice Kagan. I think first, there are threshold elements under Napue, including whether this was false testimony. I don't think it was false testimony, but I want to take your question on its own terms. This false testimony that Sneed saw a psychiatrist, that would have been harmful to petitioner under his theory of the case. Remember, the prosecution—
False is false. Whether you can parse the content of the testimony this way or that way, the critical question that a jury is asking is, do I believe this guy in everything he says? And particularly, do I believe him when he points the finger at the accused? And if I know that he has gotten up to the stand and lied about anything, whether it's important or not, it might have been important, it might not have been important. If he's lying, if he's trying to cover up something about his own behavior, I'm going to take that into account in deciding whether when he accuses the defendant, he's telling the truth.
Justice Kagan, I think in many cases where we were starting from the blank slate that the witness is presumed to be credible, one lie was important. In this case, the witness admitted that he beat a man to death with a baseball bat. The witness admitted that he was testifying in exchange for avoiding the death penalty. The jury already had significant credibility questions about Justin Sneed. And
I have to say, I find that an odd argument, Mr. Michel. It's like this witness was so not credible anyway that we don't have to consider any further lies that he tells?
No, what I think is difficult to understand is that the jury would have believed Justin Sneed and convicted petitioner despite those problems, and yet because Justin Sneed saw a psychiatrist, according to the notes, the jury would have done a 180 and reached a different result.
You know, and a Napue violation is a pretty dramatic thing when a prosecutor says, like, whoa, stop there, that was a lie. I think a reasonable jury takes that into account when it's like, wow, that was such a significant lie that the prosecutor had to sort of say stop.
I don't think that would have happened in this case, given the distinctive nature of the witness that we're talking about. I also want to underscore that this is a tangential issue. Justin Sneed testified for 5 hours. The question about lithium was about 30 seconds.
Would it make?
Michelle, what?
I'm sorry.
Oh, no, go ahead.
What do we do with the other violations that the prosecutor committed? Presumably, he lied about the knife incident, which was provoked by the prosecutor and not his initial statement. There was a ton of other withheld information. Once you find a violation and you're deciding on materiality, are you entitled to ignore all that other evidence having been improperly withheld? I know that it was in Glossip 4 and prior rulings, the court didn't find any one of those a violation. But do we ignore it? Meaning, because we would be looking at this issue de novo. So does the calculus of materiality take into account everything?
So I think this is several steps down the road. Of course, I think you should dismiss the case for lack of jurisdiction because there's
You've already lost if I'm asking you this question. So I'm
hoping I might find a few.
I give you points for trying to revive. But let's get to the end. That we accept what Justice Kagan has said, that there was a falsehood. And now you're saying there was, even if she knew about it, it wasn't material. At that point, because according to you, he lied outside of court a number of times, but does all the other withheld evidence that shows not just one or two lies, but a whole body of changed testimony, do we consider that?
I do think the court has said in cases like Kyles versus Whitley that if you get all the way to the materiality standard, I think there are many off-ramps before that in this case, you would consider all of the other evidence. I think it's notable on the knife point, however, which my friend Mr. Waxman mentioned at length, the state does not concede error on that point. The state discusses at length why.
Let me hang on just a second, because some people may not know this, so I'm going to go ahead and give you the what de novo actually means when you're talking about the Supreme Court. De novo means the court is not trusting, they don't trust the earlier rulings, so they're taking a fresh look at the issues, okay? It's fresh legal review, not considering anything from the past. They're looking at it with their eyes for the first time and consideration. So that's what that means.
It doesn't support his position on that. And that's actually the subject of the fourth post-conviction relief application.
No, but I do think that we know that he had an accomplice, a girlfriend, in prior robberies. And
wow.
He never had Mr. Sneed present at the robbery, and yet there were two types of wounds. So it suggests the presence of a second person. And if it's not Mr. Sneed, then this robbery is much more consistent with his pattern.
I think the Oklahoma
and that
court
pattern was withheld from defense counsel. So that's why I'm asking about materiality.
I mean, to be very clear, the pattern is not the knife. The question about the knife is the wounds on the body.
No, I agree.
Right.
But
the Oklahoma
had to
court
do with whether there was one or two people involved.
Mr. Michelle, I do want to ask you about the adequate and independent state grounds, because this is unusual not to accept, the waiver of the procedural bar. And, you heard us talk about that with Mr. Clement and Mr. Waxman. What's your response to that?
So, Justice Barrett, I actually don't think it's that unusual, although that's partly because we have a very small sample size. As I read the cases, there's only one case in which the Oklahoma Attorney General has squarely waived a procedural bar, and the Oklahoma Court of Criminal Appeals has squarely addressed what to do with that. And that's the decision on the fourth post-conviction review application, in which the Oklahoma Court of Criminal Appeals on page JA 775 said that it was not going to accept the Attorney General's waiver of the procedural bar bars. The Attorney General and this court, this Attorney General told you that that was an adequate and independent state ground, and that this court accordingly lacks jurisdiction over the fourth post-conviction relief application. So this decision, I actually think, does not actually address a waiver of a procedural bar, because the Attorney General, quite understandably, after he received that decision from the Oklahoma Court of Criminal Appeals, did not actually waive the procedural bar in this case. Instead, if you look at JA 976 and 977, the Attorney General says, quote, what Glossip has to do is meet the procedural bar. Then he goes on to describe the diligence prong and the innocence prong, and why, in the Attorney General's legal opinion, those requirements are satisfied. But arguing that the requirements are satisfied is not the same thing as waiving the procedural bar. And in the one case where the Oklahoma Court of Criminal Appeals has addressed that, it has said it doesn't have to accept the waiver.
What about Mr. Clement saying that we have 100 years of practice and that this is just what the law is, and procedural bars are always waivable, they're not jurisdictional?
With all respect to Mr. Clement, I don't think you have 100 years of this. I think the one case he's pointed to, as several of the justices pointed out, is the McCarty case from 2005.
Why is that? Why are you making the sample size so small? I mean, I understand that that's the only case that involves an attorney general who expressly waives a procedural bar, but procedural bars are waived of all kinds, are waived all the time. So why wouldn't what Oklahoma courts do when a procedural bar is waived, why wouldn't that be the universe of cases that we're looking at?
Well, I think I would start with the statute that's before the court in this case. I think whether that bar—
Are you saying that statute is a jurisdictional one?
I'm not saying that statute is a jurisdictional
All right,
one.
so then we're into the world of non-jurisdictional procedural bars, and the question is, what is Oklahoma's practice when a party, it doesn't have to be the attorney general, it can be a party who could have invoked a non-jurisdictional procedural bar. What does the court do?
I don't understand my friends to argue, perhaps this morning they did for the first time, that Oklahoma has an absolute rigid categorical rule trans-substantively across all areas that non-jurisdictional
No, but we don't need that.
procedural bars
We don't
have to be
need that under
accepted.
Cruz. We don't need a rule that says we have to accept it. What we need is the practice of the court when this kind of thing happens.
Right.
And so have you shown a case in which a non-jurisdictional procedural bar has been rejected?
Absolutely. The one that's before you. The one that's before you.
Other than the one that's before us. We're trying to determine whether the one that's before us is a deviation.
I'm sorry.
Right?
The fourth post-conviction relief application, which is also before
Not
you.
Mr. Glossip's situation. Do you have a case that does not involve a person named Glossip in which the court has rejected any non-jurisdictional procedural bar
Usually
that
being
is waived?
Right. I mean, usually being able to cite a case that involves the same litigant seems relatively on point, but I think there's only one other case that has come before the Oklahoma Court of Criminal Appeals where the Attorney General has waived this procedural bar. That's the McCarty case. In 3 footnotes, the Court of Criminal Appeals observed that the Attorney General had waived the procedural bar, but it did not say it was deciding the issues for that reason. And in the 19 years since McCarty—
I think, Mr. Michel, you are avoiding the question. It was a pretty simple question. One case not involving this defendant in which a waiver has been rejected.
I think there are 3 cases under this statute in which the court has seen waivers, arguably. In one of those, it rejected the waiver. In McCarty, it was ambiguous, and in this case, it was also ambiguous.
Not a case involving this. Not a case involving this defendant, and we don't have to be in Attorney General confession of error land. Just one case where the Oklahoma court says, even though a party wants to waive this procedural bar, we're going to insist on imposing it.
I have not canvassed Oklahoma law for all non-jurisdictional.
Okay, so I'm going to make this kind of a simple way to look at this so it makes it a little bit easier to understand. When the court rejects this waiver, it's talking about, we decide the rules, not the state, and that they're going to reject it. And why would they reject it? Courts want these cases to end. They don't want to reopen these endlessly cases. We know this has been touched 6 times already. It also gives institutional control to the courts so they can maintain them, that we control procedures, not the parties. And it prevents strategic behaviors. The states so you can't manipulate the rules and waive things selectively. So that's really what this is talking about. And that's why this is a big deal. with this particular waiver. Okay, here we go.
Jurisdictional procedural waivers, but I think most courts, including this court, will exercise discretion to allow those waivers in some cases and not allow them in others. And as the court
Well, I'm just wondering what the right sample size is. When we're asking this question about whether this is adequate or not, should we be looking transsubstantively or should we be looking just at this statute?
I think you should be looking just at this statute. I think that's how the court has analyzed the adequacy cases in the past. And I think several important adequacy cases here are Beard versus Kindler and Walker versus Martin, where the court looked at.
The thing that's relevant about this statute is whether or not it's jurisdictional. I don't understand how the sample size could possibly be that small, because the question we're asking is whether it's waivable, right? So I understand we have a statute, and the question is, what does a court do when this procedural bar is waived? Fine. But are you rejecting the proposition that this is a waivable bar?
I'm not rejecting that.
So you don't say this is a jurisdictional statute?
I'm not saying that. I think you could understand it that way, but that's not my position.
But you're not saying that. All right. So you accept that this is waivable, and assuming, I understand your argument is that the Attorney General did not waive it, but assuming that he did for a moment, do you have any other procedural bar ever that Oklahoma has rejected? Do we have any reason to believe that Oklahoma's practice is to look at particular statutes and it rejects some waivers with respect to certain statutes and it accepts some? No, right?
Well, I mean, I don't want to come back to it, but if you look at practice, you have the decision on the fourth application in this case, which is the only one in which the Court of Criminal Appeals has addressed this issue. So to be fair, I think that's quite relevant.
Can I ask you about the independence prong?
Sure.
So the way this is very confusing, 2 pages to me. I've read it a dozen times and I'm still not sure what each paragraph is doing exactly, what or where or why. But the first thing they say is the state has come to us and has confessed error, and we're not going to accept that concession, is what they call it. And the concession that they're referring to is the concession that he warrants post-conviction relief, right? And what the state has said in its concession, as they call it, is focuses on Napue and why it is that Napue supports Glossip here. And it says the state's concession is not based on law or fact. And that's what gets it to everything else that it does, right? Because first it has to reject the concession, and it says not based on law and fact, essentially meaning that the state's Napue argument is wrong. So before it gets to anything that might be conceived of as a procedural bar, what it has said is that the state's Napue argument is wrong, correct?
I think that's one potential way to read the opinion. I agree with you. It's not pellucid in all respects, but I do think it's pretty pellucid in paragraph 26.
If that's one way to read the only way that they go through the door to start talking about procedural bars is because they say that the state's Napue argument is wrong. They wouldn't have gone through the door except that they made this error of federal law. So this is all founded on an error of federal law. The error being that the state's concession based on Napue is incorrect in law.
I don't agree with that, Justice Kagan. I agree that that sentence comes earlier in the opinion, but I did not mean to agree that as a substantive legal matter, the court had reached the Napue issue before it was applying the procedural bars. I recognize that it's conceivable this opinion could have been written more clearly, but I do think paragraph 26 is pretty darn clear when it applies.
Okay, so let me kind of just make this a little simpler when they're talking about this independence, right? Well, it's kind of talking about even if there's a federal issue, which there clearly is, if the state says we're going to deny this based on our own rules, then the Supreme Court may not be able to touch it. It means they may not be able to change it, is what she's talking about. And apparently this was in one of the briefs that was submitted. Here we go.
Well, I guess what I was suggesting is you would never get to paragraph 26 except for the prior determination that the state's concession is wrong, which has to be a determination on the merits. Even if that's not the case, let's say that I've just made it a little bit too neat, that you have to have that the state is wrong with the merits in order to go into the procedural bar analysis, even if that's too neat. I mean, like, there are sentences in this opinion. One sentence we're talking about the merits, one sentence we're talking about the procedural bar. It keeps on going back and forth. I mean, how on earth could one reach a conclusion that the court would have done exactly what the court did if the court had a different view of the merits? I mean, everything was intertwined with everything else here.
Well, I mean, just to respond to your prior question, and I think this one too, if it's true that the court had resolved the issue on federal law, I'm not sure what paragraph 26 is doing in the opinion. I mean, there's no reason to address the procedural
It's like,
bars
and
at that
another
point.
thing.
Yeah, well, but I actually think the reason it's in the opinion is because the court is applying the procedural bars there, and that your inference, respectfully, is not a correct reading of the
I'm
opinion.
sorry, they have to decide
Oh,
the claim
boy.
was based on federal and state law.
Right.
So they might have been going to it based on the state law. But
But-
please continue
Well,
answering.
The procedural bars are a state law threshold, reasonable diligence and clear and convincing evidence of innocence. Unless
I
those
have to say that it's
threshold-
not the way these two pages are written. I mean, it would be very easy to say, before we get to the merits, the procedural bar is a state. I mean, that's so not the way these two pages are written.
Justice Kagan,
It starts with the substantive standard. Then it tells you that the state's concession is wrong as a matter of law. Then, by the way, it tells you some stuff about the procedural bar standard. Then it goes back to the merits again.
Justice Kagan, you've issued, a strong legal writing critique of this opinion, but this opinion was issued.
I haven't even started.
The question under this court's independent and adequate state ground doctrine is not how well written the opinion is.
No,
it is
but
what
actually,
did it decide the case on.
Totally right. It's not how well written it is, but it's a high bar to say that something is independent. If there's ambiguity, if there's uncertainty, we do not give that benefit of the doubt to the state under Michigan v. Long. Quite the opposite.
Justice Kagan.
So the justice is clearly upset with how that brief was written. And I get it. I understand why. Because it's like saying, why are you even in front of us if you're going to take this independently? If you're going to just say, well, the federal laws don't apply, it's just independently and state laws do. Why are you even there? I think she's very upset about this. It's really not funny, but here we go.
With respect, I think you are striving for ambiguity where there is clarity in paragraph 26. Paragraph 26 says.
Well, paragraph 26 is number one paragraph of 6 or 7, right? So I don't think that you get to just say, this is my best paragraph. You have to look at the analysis and say, is it intertwined or is it independent? And, all paragraph 26 does is to state a standard. It's like, okay, we know that they thought that this standard had something to do with something, but the rest of the 2 pages is like totally merits infused.
So I have to respectfully disagree. 26 does not state a standard. It applies the standard and says it's satisfied. Paragraph 27 in particular, if you look at the last sentence, it says, moreover, and controlling here is the fact that this issue could have and should have been raised with reasonable diligence. That's a direct invocation of the bar. I agree that there are other paragraphs in the opinion addressing the federal law issue, but as this court held squarely in Harris versus Reed, state courts were allowed to issue alternative holdings, one on the state law and one on the federal law, and that does not mean that the state law holding becomes immune from the adequate and independent state ground doctrine. As the court said in Coleman versus Thompson, it's ultimately looking for a fair, reasonable reading of what the court did. And this court, reviewing this case for the 6th time with a looming execution date on the calendar, trying to decide this quickly, trying to provide reasons for the parties and the public in a case of high public interest, did address both the procedural bar and the merits. But I think in paragraph 26 and 27, it does squarely, independently, and adequately apply the state procedural bars. That means this court lacks jurisdiction. It doesn't mean that petitioner has no other remedies available. He has the state law clemency relief available to him. My understanding is that this court dismisses for lack of jurisdiction or affirms on the merits, his execution will be rescheduled. There will then be a clemency hearing scheduled. He will be able to present his views to the clemency board. Of note, the clemency board has changed in its composition since the last clemency hearing.
Can
the
I
member
just,
of the board who was the court might be interested to know the member of the board who was recused is no longer on the board. That member has been replaced. Another member of the board who voted against clemency is also no longer on the board. That member has been replaced. So it's a new board. Sorry,
Yes,
Justice Jackson.
sorry. I'm sorry to cut you off. So you talk about a fair understanding of what the court did. Can we go to the understanding of what you think the AG did here? I understood from your argument that you said that the AG did not waive the bar in this case, and I'm just trying to understand how that could possibly be when he confessed error and asked for the conviction to be vacated on the grounds of the merits of the Napue claim. If he was also asserting the procedural bar, I don't understand how he's making arguments about the merits.
Oh, I think
not in the alternative. He doesn't say "and in the alternative," right? He doesn't say I'm invoking the procedural bar, but if you somehow think it overcome, let me go on, right?
Well, I would look at JA 976. He says, to obtain JA 976, to obtain post-conviction relief, Glossip needs to show that the issue could have been raised in a direct appeal and supports a conclusion that the outcome of the trial would have been different, citing the procedural bar.
Okay.
Then he says, at a minimum, Glossip was not made aware of Snead's treatment. That's the diligence prong.
Okay.
Then he says the state is also not comfortable asserting that the outcome would have been different. That's the innocence prong.
Does he also say I'm incorporating my arguments from Glossip 4 where he expressly waived?
He says I'm incorporating my arguments from Glossip 4, but remember, in Glossip 4, he said, I expressly waive for this case, but I will expressly invoke the bar for future cases. Enough is enough. And the Oklahoma Court of Criminal Appeals in that case told him that he wasn't allowed to waive. So I think it's quite responsible for the Attorney General to not waive.
Right, but maybe the Oklahoma's courts telling him he's not allowed to waive explains why he goes through the procedural bar, but it doesn't explain whether or not he intended to invoke it. In other words, it seems odd to me that he would be talking about the merits of this claim, trying to get the conviction vacated, but also still invoking the procedural bar. And the oddity, it seems to me, is explained by the previous attempt to waive the procedural bar that was rejected by the court. It was sort of like law of the case, and so he's talking about it in 5 because the Oklahoma court has already said, don't talk to us about the waiver.
I mean, I think we have a point of agreement, which is that after the Oklahoma court told him that he couldn't waive, which is, after all, a state law issue, then he didn't waive. He said the bar is satisfied.
But what I'm saying is, don't we have to credit his intention to waive in this case, which he expressed clearly in 4 and was told by the court he couldn't. And so I understand that your argument that he doesn't waive in 5 is, he doesn't make an express waiver statement, but of course he doesn't, because the court already told him he couldn't waive.
Well, it was his predecessor in 4, not him. And in all events, the fact that the Oklahoma court told him he couldn't waive is strong evidence that the Oklahoma court, as we discussed earlier, doesn't always accept the Attorney General's waivers. I mean, remember, we're talking about
No. I'm asking you, isn't it evidence that he expressly intended to waive?
No, the fact that he argued that the bar was satisfied is not evidence that he expressly intended to waive.
Thank you.
Thank you, counsel. Justice Thomas, Justice Alito, Justice Sotomayor, Justice Kagan, Justice Kavanaugh.
Yeah, I think you had said earlier, and I want to explore, if you get past all the procedural bars and you get to the point where the prosecutors didn't comply with their obligations, that it still wouldn't have made a difference to the jury had they known that Snead was bipolar and that he had lied on the stand. And I'm having some trouble on that last piece of the argument, if we get there, understanding that when the whole case depended on his credibility. Can you explain that some more?
Yes, and one of the critical arguments in the case, if you read the closing argument.
I mean, that is exactly what the whole argument is. It's the credibility of Snead and the fact that we have 2 violations that should have never happened. We have the Brady violation and the Napue violation. It clearly happened. It's been explained many times. But the state is trying to say, well, it wouldn't have made any difference at all. He still participated, blah, blah, blah. We've touched this 6 times. He's had 2 trials and found guilty both times. So why are we arguing this? But here we go. We'll finish it.
For example, there's extensive discussion about whether petitioner was manipulating Snead. That's probably the issue that comes up the most in the closing arguments, which are not evidence, but are a reflection of what was at issue in the trial. And therefore, petitioner's strategic decision in this case not to question Snead's mental illness, I think, was informed by the fact that he didn't want to support the prosecution's theory. And as this court explained, for example, in Wood versus Bartholomew, you can infer from the strategic decisions of the defendant what was material, what was important in the case. If the defendant himself, who has every incentive to raise the arguments that are best for him, doesn't want to raise arguments about Snead's mental health, that is a strong clue, a strong indicator that it's not material, at least material in the sense that it would change the result in his favor. It may have made the conviction more likely, but of course that's not what he needs to show for materiality.
Would have made the conviction more likely if the jury knows that not only does he have an incentive to lie, that he's lied on the stand and that he's bipolar, therefore creating all sorts of avenues for questioning his credibility?
I think that the Oklahoma Court of Criminal Appeals explained on page JA 991 that evidence that would have furthered the prosecution's theory that he could be manipulated, that he had a mental illness, would have undercut his theory and would have made the conviction more likely. Now, I do want to underscore there's lots of other evidence in the case against petitioner that doesn't relate to Snead, including his motive, including his possession of cash, including the fact that he was the only one who knew where the money would be found. And I think most importantly, his elaborate 24-hour cover-up, which cannot be explained by anything having to do with Justin Snead's mental state or whether he had a psychiatrist or whether he had bipolar. That would be, I think, the second most prevalent issue in the closing arguments. And so I think it's difficult to say the jury would have rejected petitioner's central defense that he was only an accessory after the fact, and yet turned around and accepted it if only it knew that Justin Snead allegedly saw a psychiatrist.
Thank you.
Justice Barrett? Justice Jackson?
There seems like there's some pretty significant factual questions that have been debated. What did counsel know? What did these notes markings mean? Was Snead's statement that he never saw a psychiatrist true or false? Would you object to an evidentiary hearing? As I understood it, no court has ever actually made findings on those things.
I'm not even really sure if I have standing to object to an evidentiary hearing. I don't think it's I guess we all agree that
No,
it's not,
so you all agree that it
it's
isn't
not
necessary.
necessary.
You say we can look at it and
Well,
rule in your favor. I mean, they say we can look at it and rule in their favor, but I'm just trying to understand, don't we have to have some, maybe we don't, but.
I don't want to dodge your question. I think you can dismiss and should dismiss the case for lack of jurisdiction because of the adequate and independent state grounds. If you do that, you don't have to worry about
Right, if
the
we
facts of the
disagree with
notes.
that, if we're getting to the merits, how should we go about deciding whether there was a Brady or Napue violation here?
I think you should start with the premise that it's petitioner's burden to prove the Brady and Napue violations. And based on the evidence that he's chosen to present, and particularly given that he's now told you he wants the case decided on the current record without an evidentiary hearing, I think the proper conclusion would be that he's failed to satisfy his burden. And thus, if you reach the merits, you should affirm the judgment below.
Thank you.
Thank you, counsel. Rebuttal, Mr. Waxman?
Thank you, Your Honor. I have a few short points. Number one, there is nothing that will come up at an evidentiary hearing is going to avoid the imperative, the necessity for a new trial for due process violations. If you look at the JA 1005, which is the jail medical report, there is no world in which that report, which was suppressed by the defense, by the prosecution, is not Brady material and highly, highly relevant impeachment material. There, if you look at page 953 of the joint appendix, these are the Smotherman notes, the Smotherman mid-trial note. We have to get to Justin right away. The knife is the biggest problem. There is no way that those suppressed notes, number one, don't reflect a Napue violation, and number two, are not Brady material. And with respect to the meaning of the Smotherman notes, even if you were to take the complete extra record explanation of this, which, and yes, Mr. Ackley and Mr. Smotherman were both interviewed by both independent investigations. Mr. Ackley has a declaration which in no way suggests that when he says that he was told by Snead about taking lithium, and when he was told about the discrepancy in the jail medical records, that it had to do with a relating of questions that defense counsel had had. Ms. Smotherman said when she was question number 1, I'm not sure that Trumpet is Trumka. Explanation number 2, I was referring to Dr. Trumpet, a jazz musician I wanted to hear. That was a personal note. And so when in any event, even if she's right that all Snead said was, I was questioned by the defense and I told them that I was prescribed lithium by Dr. Trumpet, given the obvious fact that this prosecutor for Oklahoma County knew as well as everybody else that Dr. Trumka was the only jail psychiatrist, she committed a Napue violation even under the Van Treese brief extra record explanation. Now, there was a question about, I think, Justice Thomas, it was yours, but pardon me if I've misallocated it, about, well, the jail records, like they weren't in the prosecutor's file. The jail records are clearly Brady material. They were under this court's decision in Kyle's and other cases. Brady material includes not only what is in the prosecutor's file, but what is also in the police and investigators' files. That is an obligation that the prosecution has. And they were in the sheriff's office files. The sheriff's office ran the jail. The sheriff's office was investigated this crime. A deputy sheriff was called by the prosecution to report on his investigation. And Mr. Ackley at page 26, paragraph 26 of his declaration, page 939, says that he knew about jail records and misapplications. Thank you.
Thank you, Mr. Waxman. The case is submitted.
All right, so let me unshare this screen. Get rid of this. Okay, stop sharing my screen. All right, so there you go. Let me get this off of here. Now, let me tell you who Smotherman is, and this will make more sense when I tell you who Mr. Smotherman is in this case. So Smotherman is actually the investigator assigned to this case from the county, and he took the notes when they were interviewing Justin Snead. He was taking notes about Justin Snead, and that is where part of this comes from. And so when they're in trial, they're talking about things, and they're talking about, oh, we need to get to the weapon. We need to get to the weapon. They're talking about moving on. So now listen, the oral arguments happened in October of 2024. Now we're going to go back and talk. This is a long live. I'm so sorry. It's just because this case is very interesting, and this Glossip case, it needs to be talked about because it's a credibility issue. And when you have a prosecutor, 2 violations, not just 1, but 2 violations, that's serious. It's very serious. Now, we know that Mr. Glossip had some petty, some other crimes that he's committed. We know that. But let's go back and look at Sotomayor's actual opinion that is from, this is from February of 2025, and this is the final opinion on this, right? And this is from Sotomayor. So let's go back over here and talk about it now. So remember, we were reading this a while ago, and we were talking about, well, he saw him the next day, and he had a lump on his head. He tells the guy, oh, well, I fell in the shower, and I hit my head, and that's what the lump was from. This is the story that Glossip is telling other people about Snead. However, we also know now that Glossip knew what Snead had done and helped him cover it up, right? So let's go back to where we were starting at. All right, so he goes, remember the last thing we said was he was like somebody punched him. Then he goes, well, in this application for post-conviction relief, Glossip police interview on January the 8th of 1997, Glossip added that Snead had told him he slipped in the shower. Glossip disclaimed any knowledge of the Vanteresa's murder, but admitted that he helped Snead replace from the outside the broken window of the room where Vanteresa's body was later found. Now, this was the next day. Officers arrested Glossip in front of an attorney's office with approximately $1,700 in cash on him. They believed that this money came from Mr. Vanterese. Okay. Glossip then admitted Snead had told him that he had killed Barry. Glossip police interview on January the 9th, when confronted with his prior inconsistent statements about the murder and Vanterese's whereabouts, Glossip said that he had been scared to tell the truth because he feared his failure to notify the police immediately meant he was already involved in it. Trying to think ahead, see, that's what he's doing. The state thereafter charged Sneed with capital murder and Glossip as an accessory after the fact, based on his inaccurate statements to the police. Eventually, police located and interviewed Sneed, who had $1,680 in bloody cash on him. So Glossip took the clean money and left the dirty money over there with Sneed. Then the next thing that happened on May the 28th, I'm sorry, the officers told Sneed that before he made up his mind on anything, they wanted him to hear some of the things that they had to say, including that they did not think Sneed had acted alone and that he should not take the whole thing himself. All right. He goes, everybody was making Sneed the scapegoat in this. They told him, especially Glossip, who was putting him in the worst, right, making it on him. Sneed initially responded to the officer's prompts by attempting to implicate his brother, but eventually said that Glossip had wanted to steal Van Tress's money and that Van Tress's death had been the result of a robbery gone wrong. Okay. Sneed described the breaking into the Van Tress's room and beating him with a baseball bat until he figured he was knocked out. So he didn't really think he was killing him. He thought he was just knocking him out to steal the money. Okay. So then he says, according to Sneed, he then took Van Tress's car keys, stole an envelope that had approximately $4,000 in cash from his car, and split the money with Glossip. When officers pressed him on the state of Van Tress's body, Sneed asserted that, actually, Glossip had asked him to kill Van Tress so that he could not run the motel without him being the boss. So, I mean, he's going for power and money and greed. That's what's going on. So the opinion of the court. Following Sneed's interview, Oklahoma charged Glossip too, so they were both originally charged with capital murder. The prosecution offered Glossip a deal, plead guilty and avoid the death sentence in return for testifying against Sneed. When Glossip refused, maintaining his innocence, the state offered Sneed the same deal, but Sneed accepted. Sneed then testified at Glossip's trial that he beat Van Tress to death because Glossip asked him to do it. When asked whether there was any particular reason why Glossip wanted to kill Van Tress, Sneed replied, not that I know of. Every time that Mr. Van Tress showed up, Glossip was wanting me to kill him. In closing, the prosecution argued that Glossip had asked Sneed to kill Van Tress because he believed Van Tress was planning to fire him for embezzling hotel profits. So he was stealing from his employer, which was Mr. Van Tress. Wow. So Van Tress, he was going to fire him for stealing. The jury convicted Glossip and sentenced him to death. The OCCA unanimously reversed Sneed's testimony. They reversed this. Sneed's testimony was the only direct evidence connecting Glossip to the murder it held, and the evidence at the trial tending to corroborate Sneed's testimony was extremely weak. Okay. Defense counsel's failure to cross-examine Sneed on his many inconsistent statements was therefore so ineffective and as to undermine any confidence the reliable adversarial proceeding took place. Okay, so the first time he gets his new trial based on ineffective counsel. All right, that makes sense. Then, in 2004, after Glossip rejected another plea offer, the state tried him a second time. Several witnesses confirmed what Glossip had told the police in his second interview. In the hours following Grassie's killing, Glossip feigned ignorance and lied about Van Tress's whereabouts. Hey there, you got booted again? Oh, I'm sorry, I didn't even see you there. I guess I was paying attention. Well, I'll just keep reading. I'm sorry, friend. I'm sorry, Sprinkled. I'm so sorry. I didn't hear a beep or anything. So he goes, so they try him a second time. So Glossip feigned the ignorance and he lied about Van Tress's whereabouts, as in the first trial. However, only witness Justin Sneed testified that Glossip was involved in everything, right? This time, moreover, the defense established through the state's medical examiner that Van Tress had been attacked with a knife as well as a baseball bat. Now, this is kind of where it kind of reminds me of the Gypsy Rose Blanchard case because Sneed says, "Oh, I hit him with a baseball bat. I killed him with a baseball bat." But he also had stab wounds. So are we saying that Glossip was stabbing him and that Sneed was hitting with a baseball bat, just like we think Gypsy Rose Blanchard had something to do with how many stab wounds her mother had? Because this is kind of what it reminds me of, right? Because the prosecution had not notified the defense about this change in testimony, Glossip moved for mistrial. The trial court denied that motion after the prosecution tested that the change was news to them too. Okay. The prosecution also asked Snead whether anyone had prescribed him any medication. This is where the absolute DePaul happens right here. After you were arrested, were you placed on any type of prescription medication? Answer: when I was arrested, I asked for some Sudafed because I had a cold, but then shortly after that, somehow, they ended up giving me lithium for some reason. I don't know why. I've never seen a psychiatrist or anything. So you don't know why they gave you that? He answers no. Well, there's the lie right there. Snead then confirmed that he used illegal drugs, including Mary Jane and some uh, meth, twice a week prior to his arrest. Finally, Snead testified about Gloss's purported motives for killing Ventrice. He asserted that Glossip had suggested robbing Barry of his money. And that because, and Barry was 75 years old. Let me just tell you that. Yeah, no way for a cold, right? No way. So this guy was 74 years old, okay? He goes, he said at one point that Mr. Ventrice out of the way, he would be able to not only manage the motel on council, but also, and another one that they had. So he was doing this because he wanted 2 motels to run. And that he had worried he was going to get fired because a couple of the rooms that were already supposed to be remodeled weren't. So he got paid and he embezzled that money. The prosecution weaved the suggestions into its closing argument, along with its original theory that Glossip had wanted Ventrice dead to avoid being fired for his embezzlement. Okay. He goes, Glossip was going to be fired because of the missing money. That was already known to be happening. He goes, it was then argued that Snead, satisfied and contented with his humble life, he had no propensity for violence except Glossip's direction. In other words, he would have never done this had Glossip not talked him into it, which is the same thing we think about Go to John, had Gypsy Rose Blanchard not talked him into it. Okay. It's as if Justin Snead was a Rottweiler puppy. Let's just say he's 11 months old. And Richard Glossip was the dog trainer. You can sure stick a dog on somebody, but if you're going to do that, you send a dog that's not trained or is a little bit too young. He might trip and fall. He might get scared and run away. He might do something stupid. He might not do a good job. But no matter how you slice it, no matter how you parse it, the person that says stick 'em is the person that makes the decision. Now, I don't know why they would use a dog reference there because I don't think it goes with this, but okay. This is Sotomayor's opinion. The jury again convicted Glossip of capital murder and again sentenced him to death. A closely divided OCCA affirmed holding the circumstantial evidence suggesting Glossip had mismanaged the hotel, combined with the concessions that Glossip had been dishonest in his initial statements after the murder, sufficiently corroborated with Snead's testimony that he killed Ventrice at Glossip's direction. In dissent, Judge Chappell and Judge A. Johnson argued that the majority overstate the strength of the accomplice's corroboration evidence, so they didn't really agree with it. Glossip continued to maintain his innocence in the years after his conviction, filing several habeas petitions in the state and federal court. Although the litigation did not result in relief, mounting concerns over the integrity of Glossip's conviction drew the attention of the Oklahoma legislature. A bipartisan group of 62 Oklahoma legislators retained a law firm, Reed Smith, to conduct an independent investigation into the case. So he's gotten a lot of special treatment here. All right. In June 2022, Reed Smith reported it's grave doubt as to the integrity of Glossip's murder conviction and death sentence. Independent investigations of State versus Richard T. Glossip, among other things, Reed Smith concluded the prosecution had deliberately destroyed key physical evidence before Glossip's retrial, including several items from the crime scene and the ends, receipts, and deposit books, which could have helped Glossip address the accusations of embezzlement. Reed Smith further concluded that the state had falsely portrayed Snead at the trial as a meek, nonviolent puppet. Okay. and that the key testimony about Glossip's motive and actions on that morning after the murder had been provided by a former police officer of very limited honesty and integrity. So the police officer given the information was also known not to be honest. Now that's incredibly damning, isn't it? It sure is. Wow. um, in fact, this police officer, who was jailed for making false statements shortly after Glossip's second trial, the police officer went to jail for false statements. 2 months after Reed Smith report, the states disclosed 7 boxes of previously withheld documents from Glossip's trial. These boxes contained a note that the head prosecutor, Connie Smotherman, sent to Snead's lawyer before Snead testified at the second trial. Smotherman's notes concerned a few items that had been testified to that needed to discuss with Justin, including the biggest problem, which is the knife. Who had the knife, right? So the examiner's testimony about the knife was problematic. Smotherman's note explained, because Justin told the police that the knife fell out of his pocket and that he did not stab the victim with it, yet the victim had lacerations consistent with a knife blade. It did not make much sense to Smotherman. Moreover, that Justin could have control of the bat and the knife on his own at the same time. And I highly doubt that as well. There's no way that he did both weapons, okay? That's very questionable. The boxes further contain letters from Snead to his attorney suggesting he had expressed a desire to recent testimony prior to Glossip's second trial. For example, in a letter dated May the 15th, 2003, Snead wrote to his attorney asking, "Do I have a choice of recanting my testimony at any time during my life? And is there anything you know on Glossip's court date and about recanting?" So he's already thinking about recanting his story. Okay. Based on this new evidence and the evidence revealed by Reed Smith, Glossip filed another motion for post-conviction relief with the OCCA. Among other things, Glossip argued that during his second trial, Smotherman had interfered with Snead's testimony about the knife in violation of the rule of sequestration, which prohibits witnesses from hearing each other's testimony. Oklahoma responded that Glossip's claims were meritless, but that it would nonetheless waive any procedural defenses in order to mitigate the damage from the media campaign on Glossip's behalf. Oklahoma further asked the OCCA to deny Glossip's claims on their merits as far as that the trigger the state court the difference in anticipated in any future federal review. So they didn't want this talked about. Noting that it alone would determine whether the rules of this court should be abandoned, the OCCA held that Glossip's claims were procedurally barred as well as meritless. And that's what they were talking about in the oral argument. Shortly thereafter, the state unearthed disturbing revelations about the contents of an 8th box of trial documents consisting of material it previously prevented the defense from obtaining. There is the Brady violation right there. And that is a Brady violation. Don't think it's not, because it absolutely is. Brief for respondent number 10. Buried inside box 8, the state says, was a page of notes handwritten by Smotherman during a pretrial interview with Snead, indicating that Snead had told Smotherman that he was on lithium not by mistake, but in connection with Dr. Trumpet. Oklahoma's Attorney General deduced that the importance of these notes in short order. Only a single psychiatrist worked at the Oklahoma County Jail where Snead was held when Snead was held there, and his name was Dr. Larry Trombanka. Okay. A summary of Snead's medical records previously withheld from Glossip's counsel after the motion. So they held it. He never saw this until afterwards, right? After the motion practices seeking their discovery, showing that Snead had received the lithium to treat his undisclosed bipolar disorder. Now, let me make this clear that Glossip had no mental illness. There's no record of Glossip having any mental illness, but there is record of Snead having mental illness, okay? The Attorney General accordingly determined that Snead was not, in fact, misprescribed lithium, but rather diagnosed with bipolar disorder and treated with lithium under the care of a psychiatrist. And despite her knowledge of these facts, Smotherman elicited false testimony from Snead on that subject, and the brief respondents in number 11. Okay. The Attorney General thereafter disclosed in Box 8 to Glossip and retained an independent counsel to conduct another review of Glossip's convictions. As relevant here, the independent counsel concluded that Smotherman's attempt to interfere with Snead's testimony about the knife violated the rule of sequestration, that her failure to turn over Snead's statements about his mental health treatment violated Brady versus Maryland, which is the Brady violation, and that her failure to correct Snead's false trial testimony that had been given to lithium after asking for cold medicine violated Napue. And this is the two things that was talked about in the oral arguments we just listened to. Okay. Now, the state must vacate Glossip's convictions due to its decades-long failure to disclose what I believe is Brady material and correct what I believe was false trial testimony of its star witness and what I believe was a violation of the court-ordered rule of sequestration of witnesses. In my view, this case is also permitted by failures to secure safeguards and maintain evidence in a capital murder case. Now, this is Sotomayor giving her opinion. Following the Box 8 disclosure and the independent counsel's recommendations, Glossip filed successive petitions for post-conviction relief with the OCCA asserting Brady and Napue, cumulative errors, and actual innocence claims. The Attorney General filed a response in support of the petitioner's successive application for post-conviction relief. So, they have said, yes, this was wrong, right? They said it was wrong, and then the Attorney General gets involved. But here's where it gets kind of weird. It gets weird over here. Okay. Although the Attorney General did not endorse Glossip's actual innocence claim, he represented that his office had concluded that Justin Snead made material misstatements to the jury regarding his psychiatric treatment, and for these reasons, for his lithium prescription, which the state had failed to correct in violation of Napue. In addition, the state indicated it was concerned that there were multiple and cumulative errors, such as a violation of the rule and destruction of evidence, that when taken together with Snead's misstatements, warrants a new trial. Okay, so the state believes Glossip is entitled to post-conviction relief. And then the next thing, okay, so that's going to happen. The state requests that the court vacate Glossip's conviction and that the case be remanded to the district court. So it's going to go back down to the district court to be retried. Because Oklahoma agreed with Glossip on the pertinent facts, it did not request an evidentiary hearing, which is another thing that was just discussed in the oral arguments we just listened to. The OCCA denied Glossip's unopposed. So let me tell you how this goes. So we heard the oral arguments. This is Sotomayor's actual opinion after the arguments were over. She wrote the opinion for it, okay? So Glossip's unopposed petition without a hearing. It acknowledges that the Attorney General's request that Glossip's conviction be vacated, noting that this is concessions alone, did not directly provide ground for relief. The court said the following about the state's confession of Napue era. All right. Glossip claims the state failed to disclose evidence of Justin Snead's mental health treatment and that Snead lied about his mental health treatment to the jury. Though the state, in its response, now concedes that this alleged false testimony, combined with other unspecified cumulative errors, warrants post-conviction relief. The concessions alone cannot overcome the limitations and successive post-conviction review. Okay. Then we walk along, and so the state's concessions is not based in law or fact. The OCCA then applies Oklahoma's Post-Conviction Procedures Act to hold that Glossip claims were procedurally barred. It concluded separately that the evidence presented by the parties did not create a Napue era. The court thereafter stated that Glossip's execution at the joint request of the parties and granted a certiorari to consider Glossip's Brady and Napue claims and the effect of the Attorney General's confessions of errors. The court also requested argument on additional questions whether the OCCA's holding that the PCPA precluded post-conviction relief is an adequate and independent state law and its grounds for judgment. Because Oklahoma agrees with Glossip on the merits of his appeal, the court appointed Christopher Michael as the amicus curiae to defend the judgment below. This is a lot, but it's very interesting. He has ably discharged his responsibilities. This was it. Okay, so we begin with the court's jurisdiction to review the judgment. The court will not take up a question of federal law presented in this case. if the decision of the state court rests on the state law ground that it's independent. We just talked about, remember, the independence versus the federal. We just talked about that. Okay, so in the context of the direct review of the state court judgment, the independent and adequate state ground doctrine is jurisdictional, and it talks about the cases that it applies to. A state ground of decision is independent only when it does not depend on federal holdings, okay, and also is not intertwined with questions of federal law. When the adequacy and independence of any possible state law ground is not clear from the face of the opinion, we will accept as the most reasonable explanation that the state court decided the case the way it did because it believed that the federal law required it to do so. So they would not allow it to be held independently, is what I understand. Amicus argues that the court lacks jurisdiction because the OCCA held that Glossip's claims were barred under the PCPA and that the PCPA is an independent and adequate state law ground. Brief for court-appointed amicus curiae. The court argument fails because it overlooks because it overlooks the holdings that turned on federal law. The OCAA first rejected the Attorney General's confession of Napue error, deeming that meritless and therefore incapable of overcoming application for the PCPA. Only then did it apply the PCPA to Glossip. Because the OCAA's decision to reject the Attorney General's confession of error rests exclusively on a federal law, so too did its subsequent decisions to apply the PCPA. Okay, now, this is Glossip versus Oklahoma, and further, this is page 14 of this brief. In his brief, the OCCA, the Attorney General disclaimed reliance on any procedural defenses, including the PCPA. Instead, the Attorney General conceded error under Napue, acknowledging that as a matter of federal law, the prosecutor's knowing failure to correct Snead's material misstatements entitles Glossip to a new trial. The OCCA held that this confession of Napue error could not overcome the limitations of successive post-conviction review because it was not based in law or fact. Okay. Wow. Specifically, the OCCA concluded that the underlying evidence did not create Napue error. Thus, the OCCA's application of PCPA over the Attorney General's confession of error depended on the determination that no Napue violation had occurred. That was a federal holding, and it was the only reason the OCCA provided for its conclusion that the Attorney General's confession could not overcome the PCPA. The PCPA therefore possesses no impediment to our review in this case. Okay. Oklahoma's precedent involving confessions of error by an Attorney General confirms this reading. As the OCCA has repeatedly explained, it will normally reject an Attorney General's confession of error only after finding that it lacks a basis of law and in the record. Okay. Where the Attorney General confesses error, the court will examine the record, and if the confession is sustained thereby and is well-founded in law, the conviction will be reversed. Okay. Otherwise, if the confession of error is supported by law and the record of the OCCA will reverse the underlying conviction and remand for a new trial. The OCCA applied that same rule here. It rejected the Attorney General's confession, and for suicidal thoughts, right? The OCCA applied the same rule here. It rejected the Attorney General's confession of error, having no basis in law or fact, and explained that it would therefore apply the PCPA. In doing so, the OCCA made application of the procedural bar dependent on the rulings of federal law, that is, on the determination of whether federal constitutional errors had been committed. And as far as I'm concerned, they were committed, but I'm not a member of the Supreme Court, so I cannot make that determination. After all, it made application of the PCPA contingent on its determination that the Attorney General's confession of federal constitutional error had no basis in law or fact. To the extent that the OCCA's reasoning on this point is insufficiently clear from the face of the opinion, we nonetheless presume reliance on the federal law. This court therefore has jurisdiction to review the judgment below. So now they're saying, okay, we have the right to review it. The dissent dismisses all this as invented federally holding that the OCCA never made. As the dissent sees it, the OCCA rejected the Attorney General's confession of error because the dissent says the state failed adequately to address all the PCPA's procedural requirements. Okay? The OCCA plainly held that the Attorney General's confession was not based in law or fact. However, forcing the dissent to provide an awkward explanation that this holding about the federal confession of error on the merits was only about the PCPA's state law procedural requirements. Yet the state expressly attempted to waive those procedural requirements by arguing that Glossip was entitled to a new trial. The state requests that the court vacate Glossip's convictions and that the case be remanded to the district court. So to explain why the based in law or fact language, the dissent must proceed on the assumption that Oklahoma law requires applicants to satisfy the PCPA non-jurisdictional provisions, even when the state waives them, and even if the state confessions of constitutional errors is otherwise meritorious, notwithstanding that many other contexts where the OCCA privileges and confessions of error. Boys, this is a lot, I know. So it comes down to the assumptions is hardly clear from the face of the opinion below. And it's talking about the other opinion that was given. Thus, we must accept as the most reasonable explanation that the state court decided the case the way it did because it believed the federal law required it to do so. So it's going back to that, okay, now we're back in the federal law instead of the independent law of the state. Turning to the merits, we conclude that the prosecutions violated its constitutional obligation to correct false testimony. So in other words, there was a Napue, right? This court held that the conviction knowingly obtained through the use of false evidence violates the 14th Amendment of due process. Yay! To establish a Napue violation, the defendant must show that the prosecution knowingly solicited false testimony or knowingly allowed it to go uncorrected when it appeared. And that's exactly what happened in this case. If the defendant makes the showing the new trial is warranted, so long as the false testimony may have had an effect on the outcome of the trial. That is, if it, in any reasonable likelihood, could have affected the judgment of the jury. In effect, this materiality standard requires the beneficiary of the constitutional error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict obtained. Here, Oklahoma's Attorney General joins Glossip in asserting a Napue error, conceding that Snead's testimony was false, and the prosecution knowingly failed to correct it. The record supports the confession of error. A summary of Snead's medical records created by the local sheriff's department establishes that someone diagnosed Snead with bipolar disorder and prescribed him lithium. Okay. And that Dr. Tromka, a psychiatrist, attested to this in a sworn affidavit that he was the only medical professional at the county jail, and that he issued Snead the prescription. Dr. Tromka also confirmed, and nobody contests that the lithium is used only in psychiatric treatment and not for dental pain, as Snead said at a pretrial hearing, or for a cold. Nor would anyone confuse lithium with Sudafed, which is a cold medication. Snead's trial testimony that he had been given lithium after asking for Sudafed and had never seen a psychiatrist or anything was therefore false. Okay. The evidence likewise establishes that the prosecution knew Snead's statements were false as he testified to them. The prosecution almost certainly had access to Snead's medical file, which would have listed both lithium prescriptions and the bipolar diagnosis. Among other things, those records would have been provided to the state as part of Snead's competency evaluation. And, liar, liar, that's right, liar, liar, pants are on fire. I mean, she clearly violated his rights. I mean, this is a Fourth Amendment rights. Letitia Stout needs to shut the fuck up. She's always claiming how her rights are violated. No, hers aren't, but this guy's are. Okay, so, now, among other things, those records would have been provided to the state as part of Snead's evaluation. The state opposed Glossip's discovery request of Snead's medical files on its merits. And the dissent emphasizes, moreover, lithium is prescribed only for mood disorders. The brief for the court-appointed amicus curiae It is undisputed that the lithium's sole medical purpose, both in 1997 and today, is to treat bipolar disorder and other mental health disorders. Yeah, Letitia has no rights as far as I know, me neither. She's always lying, right? Yet the prosecution knew that Snead had previously told competency evaluator that he had been prescribed lithium after his tooth was pulled. See, he's not, look, Snead just, it doesn't sound like he's competent to me. The statement was part of a competency record to which both the state and Glossip had access. Prosecutors then heard Snead testify to a different version of events in trial, that the lithium had been given to him after he asked for Sudafed because he had a cold. In addition, Smotherman's notes show that she had pretrial conversations with Snead at which he mentions his lithium and Dr. Trumpet. Glossip argues the Attorney General admits that this shows Snead told Smotherman that Dr. Trumpet, meaning Dr. Tromka, had prescribed the lithium. As just discussed, the record shows the fact that Dr. Tromka did diagnose Snead with bipolar disorder and prescribe the lithium. Snead plainly discussed this matter with the prosecution. In that private conversation, he would have had little to gain he would have little to gain if he would have lied about his prescriptions, nor do the notes suggest he did anything of that kind. Like, he wasn't intentionally trying to hide it, okay? He just wasn't. Sudafed for allergies, right. So he wasn't trying to hide it. The straightforward interference is actually that Snead told Smotherman that Dr. Trompa had prescribed him the lithium. So he told the truth. So Snead tells the truth to the prosecutor. That leaves a materiality. Evidence can be material even if it goes only to the credibility of the witness. The jury's estimate of the truthfulness and the reliability of a given witness may well be determined in the guilt or innocence. Because Snead's testimony was the only direct evidence of Glossip's guilt of capital murder, the jury's assessment of Snead's credibility was necessarily determinative here. Besides Snead, no other witness and no physical evidence establishes that Glossip orchestrated Van Tress's murder. Thus, the jury could convict Glossip only if it believed Snead. This is where the problem is here. Had the prosecution corrected Snead on the stand, his credibility plainly would have suffered. That correction would have revealed that the jury that Snead was untrustworthy, and that the jury already knew he repeatedly lied to the police, but also that Snead was willing to lie to them under oath. Such a revelation would be significant in any case, and especially so where Snead was already nobody's idea of a strong witness. So they already had doubts that he was going to be credible. So in the brief of the court appointed amicus curiae, even if Snead's bipolar disorders were wholly irrelevant, as amicus argues, his willingness to lie about it to the jury was not. A lie is a lie, no matter what the subject is. Okay. Snead's false testimony also bore on Glossip's guilt in a more direct way. As Smotherman's co-counsel, Gary Ackley had conceded it would have been an important fact for the defense to know that Snead had been prescribed lithium to treat bipolar disorders. After box number 8 disclosures, Dr. Tromka explained that Glossip's counsel that the bipolar disorder symptoms can be exacerbated by illicit drugs, such as meth, to cause an individual to be more paranoid or potentially violent. Snead admitted at the trial that he regularly uses drugs, including meth. His diagnosis with a disorder that could trigger impulsive violence when combined with drug use thus would have undermined the prosecution's theory that Snead was harmless on his own. See that? Right. That's why she covered it, right? That's exactly why. And then it uses some reference of a Rottweiler puppy beholden to his trainer. I don't like the dog references they're using. I don't think that's right. The theory was an important part of the prosecution's case and featured prominently in its opening and closing statements, arguing in the opening statements that Snead was pretty content doing whatever it was that Richard Glossip wanted him to do. So he was like a puppy that just did whatever Richard said. Okay. Emphasizing in the closing that Snead would have never committed murder without Glossip, just like Goldie John would have never committed murder without Gypsy Rose Blanchard. Yeah, I'm saying it. I damn sure am. Snead's testimony hence there is a reasonable likelihood that correcting Snead's testimony would have affected the judgment of the jury. Amicus objects that the jury already knew that Snead had been prescribed lithium, used illegal drugs, and is impulsive. He admitted that he beat a man to death with a baseball bat in the middle of the night with no advanced planning. Brief for the court of appointed amicus curiae. As amicus sees it, and additional evidence provided by Snead's lies and his treatment for bipolar disorder could hardly have made a difference in light of so much other impeaching evidence. Of course, at a trial, the prosecution has urged the jury to believe just the opposite, that despite his prior dishonesty and violence, Snead was now telling the truth. A prosecutor's mid-trial revelation that Snead lied on the stand would have significantly undercut their argument. That's right, they would have had nothing against, the other guy. In event, amicus positions itself defeating. If the evidence impeaching Snead's credibility was already overwhelming, then the reasonable jury could have convicted Glossip in the first place, even if the prosecution's case rested centrally on Snead's credibility. Amicus appears to assume that the jury would have believed Snead no matter what. Such an assumption has no place in materiality analysis, which asks what a reasonable decision maker would have done with new evidence. Okay. Then it goes down to rejecting the argument that the evidence was immaterial because witnesses' credibility was already impinged. Although the prosecution's failure to correct Snead's false testimony was material, it was a Napue violation on its own, and additionally, conduct by the prosecution further undermines the confidence in the verdict. The Attorney General has confessed to the violation of the rule with respect to Smotherman's apparent mid-trial attempt to speak with Snead about the knife, as well as to destruction of evidence, including the hotel's financial records and the items of evidence, and items Glossip and Snead allegedly handled in Brad Teresa's room. Glossip and Snead, okay, then it says, see the brief 13-3, okay. I was informed that a box of evidence containing 10 items was destroyed by the Oklahoma City Police Department. It is likely that I was aware of that fact during the 2004 retrial. So as far back as 2004, this box of evidence was destroyed and it was known to be destroyed. That this happened horrifies me. This is Sotomayor talking. This is, Supreme Court Sotomayor, the Supreme Court Justice. Independent investigations of State versus Richard E. Glossip, cataloging destroyed items. In addition, the 8 boxes of documents released to Glossip, including statements from Snead, evincing a desire to his recent testimony and witnesses' notes with details not previously turned over to the defense. For example, the file suggests that one witness told the prosecution, contrary to his trial testimony, that Glossip sold him a couch and a TV for $900. So what's happening here is in this brief, now we're finding out there was a witness that said $900 of the money that Glossip had, he got from selling furniture. That evidence would have supported Glossip's account of the cash he carried at his arrest outside the attorney's office, that he had sold his possessions to pay for an attorney. Because prejudice analysis requires cumulative evaluation of all evidence, whether or not that evidence is before the court in the form of an independent claim for relief, these documents reinforce our conclusion that a Napue era has prejudiced the defense. For these reasons, we conclude that the prosecution's failure to correct Snead's trial testimony violated due process clause, and Glossip is entitled to a new trial. Then he goes on to Section B. The OCCA's contrary holding rested on a mistaken interpretation of Napue. According to the OCCA, there was no violation because the defense was aware or should have been aware that Snead was taking lithium at the time of the trial, and the prosecution could not have knowingly concealed something the defense already knew. As an initial matter, Snead's false testimony concerned the reasons for his lithium prescription, not the mere fact that he had taken it. Glossip's counsel was aware of the latter, not the former. In any event, the due process clause imposes the responsibility and duty to correct false testimony, representatives of the state, not the defense counsel. The OCCA also held that Snead's testimony was not clearly false because Snead was more likely in denial of his mental health disorders. I don't think I'm going to go with that one. I don't believe that. The OCCA also held that Snead's testimony was not clearly false because it was more likely that he was in denial. Then it says, It is not apparent why the OCCA thought Snead was in denial, nor why such denial should have caused Snead to believe that he had never seen a psychiatrist when in fact he had. Even supposing it did, however, Snead's beliefs are false and the prosecutor knowingly let it stand nonetheless. It is a Napue violation, absolutely. Okay. It is established that a conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The dissent's arguments in support of the OCCA's conclusions fare no better. As an initial matter, even the dissent does not dispute that Snead falsely testified he had never seen a psychiatrist. Okay? Suggesting that Snead misremembered that the psychiatrist prescribed him the lithium to treat his bipolar disorder. The dissent does maintain that the other aspects of Snead's statements were true, noting that because Snead was in denial about his diagnosis, his statement about his own knowledge was not false. Okay. Snead's statement that he asked for Sudafed to treat a cold and was given lithium instead. See, that that makes no sense. Okay. Was not, however, a statement about his own knowledge. Even if Snead himself did not believe that he suffered from bipolar disorder, moreover, that would not render true his assertions that he had no idea why his doctor thought he needed lithium. The dissent next claims that the false testimony must itself have directly affected the trial's outcome to be material under Napue. Okay? The relevant inquiry under Napue is whether the content of the false testimony at issue is material. As to Napue made clear, however, a lie is a lie no matter what the subject is, and I agree with that. Okay. It says nothing in Napue requires ignoring the fact of Snead's perjury in the prejudice analysis. To the contrary, materiality, instead of always requires courts to assess whether the error is complained of could have contributed to the verdict. Here, the prosecutor's failure to correct Snead's false testimony is a relevant error. The court asks whether that a correction could have made a material difference. The answer is clearly yes. The remaining arguments offered in the defense of the OCCA's position are likewise unpersuasive. In an amicus brief, the Van Tresser family argues that it was Glossip's counsel who asked Snead about his lithium prescription. They may not be remembering correctly themselves. I mean, that's something we don't know. And that Smotherman's notes reveal only that Snead relayed those questions to Smotherman. See the brief for the victim's family members, Amy Cure. The argument relies heavily on extra record materials not properly before the court, including a recent unsworn statement from the Smothermans adopting the family's interpretation of the notes. The dissent, which criticizes the independent counsel for impugning the trial prosecutor's reputation. Well, when you don't tell the truth, you don't tell the truth. It justifies its reliance on the materials by accusing the Oklahoma Attorney General of collusively excluding them from the record, nor would accepting the family's account change the Napue analysis. Whatever the impetus for the conversations, the family agrees that Snead and Smotherman discussed Dr. Tromka and the lithium. The natural inference is that Snead explained to Smotherman that the circumstances that led to his lithium use. To avoid that inference, the family in turn suggests both that Snead was never diagnosed with bipolar disorder in the first place. The brief for the victim's family members, Amiki Cure, and the Glossip Council knew about Dr. Tromka more than 2 decades ago. Remember, this case has been going on for 25 years. 25 years of this. It's crazy. Lots of money spent on this case. Oh boy. Yet, for the reasons previously explained, the defense counsel's purported knowledge of Dr. Tromka's existence is irrelevant, and that the prison medical record supports the Attorney General's concession that Snead received the lithium prescription as treatment for a bipolar disorder. The family also maintains, and the dissent agrees, that Reed Smith and the independent counsel spent insufficient time interviewing Smotherman. Neither the family nor Smotherman raised that objection before the OCCA, nor does anyone now explain its relevance to the Napue analysis. The argument is as unpersuasive on its own terms. Both the investigators spoke to Smotherman. When they did, Smotherman did not provide the account she now endorses that Snead relayed to her a conversation with Glossip's counsel about Dr. Tromka and the lithium. Instead, during a third interview of this person, Smotherman asked the independent counsel why he thought it was Dr. Tromka and not Dr. Trumpet the jazz musician, and why I was making a personal note or something else. Well, you're trying to cover yourself right there because what you're saying does not go with this case at all. That's what I see. There's no compelling evidence that a fourth or fifth consultation with Smotherman would have yielded materially a different result. The court-appointed amicus, for his part, largely abandons the OCCA's reasoning and focuses instead on ambiguities in the Smotherman's notes. Amicus maintains that from the conclusions that the Sneed lied on the stand and that Smotherman knew it. For example, amicus argues the parties do not explain the basis for their asserted link between Dr. Trumpet and Trumka, reiterating Smotherman's earlier statements that she is not convinced that Dr. Trumka or Dr. Trumpet are the same person. Brief for the court-appointed amicus curiae, as already explained, however, there is ample evidence in the records before this court supporting the interference that Smotherman knew about Sneed's psychiatric treatment and the lithium prescription, including the prison medical records, that Dr. Trumka attestations and Smotherman's own notes. Because ample evidence supports the Attorney General's confession of error in this court, there also is no need to remand for further evidentiary proceedings at the OCCA. Indeed, that such proceedings are not necessary is the one point of which Glossip and Oklahoma amicus in the OCCA unanimously agree. I guess we all agree that an evidentiary hearing is not necessary. The partial concurrence suggests that the court should nonetheless remand for further proceedings on the ground that the evidence does not remove all the doubt that the Attorney General's view of the record is correct. Yet, for the reasons already explained, the record establishes a violation of Napue. This court has not required an evidentiary record free of doubt to find Napue violations in any case, much less when an Attorney General confesses that its own office erroneously obtained a capital conviction. I mean, and we're going to go on to C, Part C. Finally, the dissent maintains that this court lacks the authority to remand for a new trial, but its analysis proves the contrary. The dissent emphasis on our only power over state judgments is to correct them to the extent that they incorrectly adjudge federal rights. It further agrees that where a state court relies on a procedural rule, where applications turns on whether the federal constitutional error has been committed. It clearly has. This court may remand for a new trial if it's confidence that no other state ground could support the decision below. Those principles describe this case. As explained above, the OCCA incorrectly adjudged Glossip's federal rights. In doing so, it relied on the procedural rule whose application turned on the merits of a federal claim, where the Attorney General confesses error, will examine the record, and if the confession is sustained thereby and is well-founded in law, the conviction will be reversed. They don't have a choice but to reverse it, really. Okay, so, opinion of the court. This is the next part here. Here, the Attorney General's concealed error under Napue, and the OCCA rejected the confessions because it wrongly concluded that no such federal error had occurred. Because the Napue confession was well-founded in law, it follows that the conviction will be reversed. Accordingly, all that remains below is to vacate the conviction and a new trial follows at fortiori. The dissent concludes otherwise because in its view, a remand for further considerations of alternative state grounds is mandatory in every case where Michigan versus Long resolves lingering doubt over the court's jurisdiction. Long describes the circumstances under which this court has jurisdiction to review a state court's judgment. It does not limit the court's remedial authority over an established federal constitutional violation. Nor does any precedent support the dissent's rule. The state courts who grant relief to criminal defendants under an erroneous interpretation of federal law may later grant relief as a matter of a more protective state law. Plainly, okay, then it goes Kansas versus Carr, and then it's talking about Sotomayor dissenting plainly does not deprive the court of the authority to grant relief where it finds federal violations, contra post Act 35, which is Arizona versus Evans. Under Michigan versus Long, the state courts are absolutely free to interpret constitutional provisions to accord greater protections to individuals' rights than to do similar provisions to the United States Constitution. The dissent inverts that this precedent, asserting that the state court should always have another opportunity to identify additional grounds for denying relief, even where this court has found a federal constitutional violation. Yet there is no reason to allow state courts a second, third, or fourth bite at the apple to identify alternative state grounds for their decision in every case involving dependent grounds. The facts as conceded by the Attorney General and supported by the record established a violation of Napue. A new trial is the remedy for Napue violations, and this court has jurisdiction and the Napue violations occurred. Thus, Glossip is entitled to a new trial, vacating the conviction and remanding the case to the OCCA under similar circumstances. The judgment of the Oklahoma Court of Criminal Appeals is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered by Justice Gorsuch, who took no part in, okay, so Justice is Gorsuch, took no part in the considerations of the decision of this case. So there you go. That was Sotomayor's actual opinion. I mean, there's also Judge Barrett concurring. Judge Barrett also gave an opinion. Now, there's 82 pages to these opinions, and I'm not going to be able to read them all today. There's also Justice Thomas gave an opinion. So it looks as if, let me go over here a minute. Hang on, guys. Let me go back up to the top because there's a spot over here. I'm going to hang on a minute. Whoops. Okay. Ooh, 82 pages. No, there's no way I could read 82 pages right now. It's kind of late. We've already been on here 3 hours and 20 minutes. Woo, that's a long time. But it's a very interesting case, and a lot of things happened here. And clearly, the violations happened. Now, when these things happen, what happens? What happens to the prosecutors who make these mistakes, who make these errors, who actually know they're making these errors, right? So in summary, the Supreme Court reversed Glossip's conviction, ruling the prosecutors violated constitutional duty under Napue by allowing false testimony about Snead's lithium treatment and mental health, which was material to the verdict. The court emphasized the importance of correcting false evidences and found procedural barriers insufficient to prevent review and ordered a new trial highlighting prosecutorial misconduct and evidence suppressions. So how does let me say, how does this judgment affect the parties? That is the main question here. Okay, let's see what we got to say here. Hang on. Let's take a look. This is how it affects. Okay, it says, what? You're not going to respond at this term. Hang on a minute. A few more. The Supreme Court is civil. Okay, this is a syllabus about this. Let's see. Be sure to double check. Okay. Well, how it affects the parties is the fact that he's getting a new trial. That's it. That's over. I mean, I don't know when this new trial is going to happen, but here's the case. I hope that they have a new prosecutor because both times he was tried before, it was under the same prosecutor. How does that work? How does that work? So let me see something. Hang on a second. Let me pull this up. Okay. I have seen the parties to the case, really up to the parties. Okay. I have seen cases where they have tried him a couple of times and then they just decided to drop it and not try him at all. They just walked away from it, So, effect. Hang on a minute. Let me pull this up over here. Hang on, guys, just a minute. Okay. Oh boy. So, in real world, how the Supreme Court's ruling affects all the parties. That is the question, right? The death sentence is no longer valid. The conviction is overturned. He gets a new trial. Okay, so the state of Oklahoma loses their conviction and their death sentence. They have to choose to either retry the case, which would mean to rebuild the case now 20-something years later with boxes of evidence that's been destroyed. How's that going to work, right? Or to offer a plea deal, or to possibly time served or lesser charge, or to drop the charges altogether. Now, if I was the state of Oklahoma, I would offer him a plea deal, basically where you've served 25 years or 27 years. You can walk out as, he could do an offer, let him take an offered charge. Just take an offer plea where he's saying, I'm not guilty, but I'm accepting what I was given. Let's talk about the offer plea real quick. You see this a lot in other cases. And the reason why they offer pleas is because they don't want to exonerate these people, because they know when they exonerate these people, they're on the hook, because the people can go back and file suit against the state of Oklahoma or the state of Texas. So an offer plea, why somebody would take it? To avoid a death penalty, to avoid life without parole, and the risk of losing at a trial. So I'm hoping if Richard Glossip was offered take an offer plea for the time served, he could maintain his innocence, accept release or reduced sentences, and avoid another trial where he could be sent back on a death penalty. It's it just gets rid of, I mean, there's weak evidence. We know the guy lied. They're missing boxes of evidence now that's already been proved that they were destroyed. So it's a very weird case, and I'm gonna keep track of it because I'm just shocked by how this all went down. I really am. I'm gonna get off of here now. It's been 3 hours and 24 minutes. We usually don't go that long, but when you're talking about trials and oral arguments and the briefs that come with it, it's very interesting. Very interesting. Anyway, you all have a good night. See you later. Go out there, hug your babies. Life is short and your time with them's even shorter. Be safe out there. Bye, guys. Thanks a lot. Oh, remember to hit that like button on your way in or out. Either way, thank